Your Lordship directed my friend to file counter affidavit, and on the basis of the submission made by my friend, my Lordship, Your Lordship has adjourned the matter today to
You are fine.
the supposed counter.
Not required.
My
I am
Lordship-
satisfied,
No,
Lordship.
no, it's not a question satisfying. That is your detailed order, my Lordship.
No.
Only Your Lordship respect
It
the
is
order
a-
passed by the Honorable Court, my Lordship.
It is a
And
read-
on the
it is a
submission,
read-
my Lordship, just a minute, just a minute. Your Lordship, kindly see, Mr. Satapathy, Lord Advocate, Senior Standing Counsel, appears on behalf of Revenue and submits adjournment be granted for filing affidavit on contentions of department without prejudice. He submits account.
So you have
Account-
filed it.
Oh,
I have
no,
not
he
filed.
has
I
not
take
filed.
instruction.
You file it. You file it, I'm fixing it for 21st. In the meantime, you file it. 21st September.
No, 25th. No, let's keep it 25th.
25th.
25th, I am not there, so
26th.
26th.
Yes.
26th, yes.
Okay, 26th. That's to the revenue.
Interim to continue matters.
By
Item number 2. Item number 2 and 3, Your Lordship. Mr. Patnaik is an accommodation. He's suffering for favor, my lord. My lord, can you come next week?
who? Mr. Patnaik.
My lord.
What is this? This is part service. Part service.
He's suffering for favor, my lord.
You don't know. 25th. 25th.
Yes, Lord. Item number 4.
My lord, first appeal order under GST Act is under challenge, my lord. Similar order, 10%
Give the
of the
order.
disputed, 10% of the disputed tax has already been paid.
Paid another 20%.
Yes, my lord. Obliged.
Next.
Item number 5.
My lord, just now I have received information and instruction from my senior that he is suffering from dengue. So my lord, he requested me to take 7 days time.
When? 7 days.
7 days time, my lord.
Okay, 27. I can't say no.
Oh,
I will bring you.
27th.
Obliged, my lord.
My appearance may can.
April.
Item number 6, I have to file counter.
6 5.
Interim order to be continued.
Revenue. 2 weeks time.
Yes.
File the counter. This is the matter on 10th of October.
Interim order to be continued.
Interim order.
Item number 7.
7.
My lord. May I please, Lord?
What is the issue?
Issue is the.
3A.
My lord?
3A of entry tax.
No.
What is
It's GST was imposed. OST at rate that 20% was imposed on the sale of BD, my lord.
Hmm.
This is covered by the judgment of this honorable court, which was upheld by the apex court, my lord.
What is that? What is the judgment?
Judgment I have annexed, my lord. Annexure 1 and 2, my lord. 1 is the judgment of our court.
Just 1. The Manupatra. No, this is the High Court of Orissa. Okay. Ashok Beri. So what is this judgment?
This judgment
What is
says,
the finding of this judgment?
finding is that only CST at the rate of 4% can be imposed on the sale of BD, my lord, at that time.
Okay.
They imposed 20%. Thereafter, honorable High Court directed to refund of the differential amount along with 16%.
They had charged 20%.
20%.
But actually, this judgment says 4%.
4%, my lord. Thereafter, it was upheld by the apex court, annexure 2, my lord.
Hmm.
Annexure 2 at page 24, my lord.
So then you went to apex. Okay. Right. What do you say?
My
He
lord,
not covered
no.
under this judgment?
My lord,
No, what happened? May I pray? Thereafter, after passing of the judgment of this honorable High Court, they this petitioner bought 2 sets of BD, my lord.
Even after the judgment of the Honorable High Court, they imposed 20%. Thereafter,
I understand, sir, 20% they are imposing, so you want that there should be 4%. That is your.
No, they admit after 20 years, even that I am entitled for refund. But regarding the interest, I have come before their lordships, my lord. Lordship may kindly have a glance at the last.
Supreme Court has granted interest.
Yes, my lord. Supreme Court has granted interest, my lord.
So this is pertaining to which financial year?
My lord.
This is pertaining to which year?
This is 2001, 2002, my lord.
2001, 2002. Interest, what is the percentage of interest?
Lordship may kindly have a glance at
No, what should be the percentage of interest? Is there any specific
16%.
law?
16%, my lord.
Which law says that? 16%.
This Honorable High Court as well as
I have Honorable High Court, I will Honorable High Court. Who, either dekhantu, who.
is same case.
Na, who statute 16% will lakhais. Mano icha 16% will na.
No, 2001 after the passing of the.
Sir, just I understood that. Tell me on what basis 16%? Why not 9? Why not 6? Why not 10? Why 16? That is I'm asking. I'm asking you a very pertinent question. Why 16%? Why not 10? Why not 12? Why 16? Just because High Court in a particular case said that we should also follow the same thing.
Even the Supreme Court has said.
Supreme Court might have been that particular case. Here, there is no specific direction in other case also that will happen.
No, even petitioner.
Sir, just tell me one thing. Where from you got 16%? That's all. Despite, minus this case, Ashok Biri, you forget Ashok Biri.
Ashok Biri, no.
Is there any statutory dicta that there should be 16% interest? Show me that.
Even this petitioner went in.
Sir, I am not on that. Supreme Court kaun kohila, High Court who case kaun kohila. Who case kaun kohila mu jauni. I am asking a simple question. Is there any rule, any statutory provision that provides for 16%? That's what I'm asking.
7 days time. I will get back to you.
Why 7 days time? Is it not a small thing? It can be.
Beg your lordship. I am for the opposite party number 2. I am for the commercial tax department.
Yes.
The entire dispute is against OFDC, petition number 3. This squarely covered. Your lordship had seen this. It's a purely money claim. And yesterday, your lordship had seen that judgment that it's a purely money claim because we have already refunded the amount to OFDC. There is no dispute about that. The dispute is between OFDC and the petitioner. Yes, your lordship. Secondly, they have deposited excess tax. They are now expecting that opposite party number 3 to refund back the excess tax. This reduced to be a money claim. Case 3, your lordship. Same issue, same thing.
I have been running after them since 2001, my lord. Again.
Your problem will be, we are trying to end your problem. So just hold on.
It is not against us, your lordship. The prayer is that petitioner therefore prays that your lordship would be graciously pleased to admit this writ application issue rule and be pleased to direct the opposite party number 2 to refund the differential amount of tax.
Sorry, I didn't realize that. This is OFDC also met party. 3, I was thinking that this is opposite party 3.
I am opposite party number 2.
Lordship may kindly have a glance at page 84 of the writ application. After 20 years,
don't, because 20 years that doesn't mean that you will just law will be followed anyway. Your differential amount is rupees 1,27,000.
No, theta. What a 1,27,000, what a 1,20,000.
Of the judgment.
Now you are saying some page?
Page 84, my lord.
84.
Since 2001, I have been writing to them and they wrote that after 23 years, they
Then exactly this judgment will follow. Yes, opinion number 3, you're right. He's right. Opinion number 3, this judgment will follow.
ମୁଁ ଟିକେ ଦେଖିଦିଏ ଆଜ୍ଞା।
ଆପଣ ଜାଣିଛନ୍ତି ଆଜ୍ଞା, ଆପଣ ଦେଖି ସାରିଛନ୍ତି।
ମୁଁ ଦେଖିନି
ଆପଣ
ଆସୁ ଆଉ ଗୋଟେ ଦିନ ମୁଁ ଦେଖିବି।
ରେଗୁଲାର କେସ୍ କରୁଛନ୍ତି, ଆପଣ ଦେଖିନଥିବେ।
ନା ମୁଁ ଦେଖିନି।
One more thing, so far as that Ashok BD is concerned, now that matter has been referred to a larger bench before Honorable Supreme Court.
For what?
Whether the sale will be interstate sale or intrastate sale.
I know that, that's why I was asking
Yeah,
clear or
that's-
not, I was asking
and-
initially the question, I asked that.
Exactly.
Okay, I know that, but that is not the issue here.
That is
That's
not
not
the
the
issue
Issue
here.
here is he has to get
OFDC.
a refund
Again,
from the OFDC.
Interest madhya, the
Correct.
provision is very clear.
Section 14C, your lordship will see, it is 10% from the date of.
That's why I was asking you under what provision you got 16%, I was asking him. Yeah, under what provision the 16, not 12, 10, why not?
First one is the High Court and Supreme Court.
Sir, sorry, sir, this should go, this is,
Next week, only April, let me go
you
through
see
the-
this, the judgment, pardon, the page, I'm giving you 2 minute time to read, go through it. I'll wait for you. I'm granting 2 minute time, you read it. Only substantial portion is read.
No, I'm not, lordship may see, OFDC, let notice go to the OFDC, let them, because after
Sir,
20.
OFDC notice
OFDC
जाएगी?
OFDC is a test,
No,
notice has not gone to
but-
OFDC.
Notice जाएगी?
No, notice in first time আসছে, bra.
It's a monitoring.
Anyway,
No, no,
initially, we
Cannot
can from the threshold also we can.
No,
Why OFDC पाको जीवा कौन?
OFDC state.
आपका claim तो OFDC सीधा जान पड़ता
No, they have admitted, lordship may kindly have a glance at
है. Same order.
Mr. Counsel, since your claim is a purely a money claim,
Money
no,
claim
it
is
is,
Same order, sir.
They have illegally withheld my money since 23
Sir,
years.
illegally.
maybe, sir, it's a purely money claim. You can approach the appropriate
You can-
authority.
That's you have OP number 3 against whom you are asking the claim. So that without even hearing them, we can send it because this is in at the threshold it can be sent out because it's not entertainable. Simple. So on the jurisdiction issue also we can send. The similar order. You know very well, sir. You know, they know, we don't know. Next.
Item number 8.
8, your lordship, 8, 9, they have not served copy.
Not sir. Which further? Petition.
Sir,
Amit Patnaik.
Amit,
Not there.
May it
Password?
please, your lordships.
I think it's in DC.
Lordships, I'm appearing virtually, your lordships. I may be pardoned to appear virtually, my lord.
Okay,
Lordship,
Abhishek, yes.
lordship.
What is the issue?
Lordship, here, the issue, we are challenging the tribunal's order, sales tax tribunal's order, which has been dismissed solely on the ground of limitation, my lord.
Limitation. What is the
Lordship.
delay? What is the delay period?
My lord, the delay is about 2 years, your lordships. But our
So what is your defense for the delay?
lordship, it is that we were never been communicated as to the order.
Some
Because the rules are-
delay ହେଲା some ଏମିତି କହନ୍ତି communicated ହେଲାନି
No, lordships, because the rules
ପାଇଲୁନି
are
ଆମ ଘର ବନ୍ଦ ଥିଲା ଏସବୁ ଜିନିଷ କହନ୍ତି
lordship, the rule
ଅଫିସରେ କେହି ନଥିଲେ ଗଳେଇ ଦେଇକିରି ପଳେଇଲା ଏସବୁ these are all template of your excuse.
lordship.
They are all template. Which template you are using?
Lordships, we are on the sole ground that when the rule proposes that the order must be communicated, it must be communicated to me. On receipt of the order, the period of delay starts running. The clock starts ticking only on receipt of the order. And there is a positive obligation on the authority to communicate me the order.
So what are the modes of communication? Can you tell me?
Lordship, here the mode of communication was never online, my lord, because it's that OVAT period under those acts which are no more in force. So it was physical, my lord. Everything, the
Physical mode.
communication had to be physical, lordship.
What is the 2 years, 299 days, sir?
Lordship.
The case record was
Almost 3 years.
almost 3 years.
Lordship.
And you have not explained the sufficient cause for the delay.
Lordship, we had filed the
Only simply saying
application
is
for
not
condemnation.
sufficient, sir.
Lordship may keep it to next week. We will satisfy your lordships, my lord.
What will satisfy?
My lord, that limits my subject to your lordship's consideration. That limitation on the ground of limitation, the technical issue of limitation cannot be pitted against the substantial
No,
justice, your lordship. Isn't the
That is,
demand
that is
when
for
is
a,
not?
that is for a small delay, not for 3 years delay.
Gotcha.
These things are technicalities you are talking about. For a small delay, we don't become hyper technical and just issue. Dismiss the petition. But when there is a delay, so 3 years delay, it's not a small delay, sir.
Gotcha. Gotcha.
Anyway, since you're a young counsel, so we should keep some time. Okay.
Next
So you
week
want
will
to
satisfy.
satisfy us? Okay.
Lordship, I will.
25th.
Copy maybe. Copy maybe.
Give a copy.
I'll serve a copy. Grateful.
Next.
Item number 10.
And
The petitioner filed this writ application against the first appeal order passed by the first appellate authority under the OVT Act. In passing the first appeal order, Annex 1, the first appellate authority violated the rule of law and judicial.
What is the rule of law, sir?
My lord, this court order.
Rule of law violation.
The ratio of the law laid down by this court.
The rule of law hegala.
That's
Rule
ratio
of
of the
law,
law.
do you understand? the rule of
Violated
law,
and
application of
affirmed by the
rule
Supreme
of
Court,
law?
not followed by the letter and spirit. You get quasi judicial authority ought to have followed the law laid down.
What the authority?
That the
not-
case of automobile and
Sir, what it is not followed?
the ratio of law laid down by
Which
this.
part of the order doesn't follow the rule of law
My lord.
as per your submission? Yes, show me which part of the law has not been followed.
My lord,
ଏଇଟା ତ ଛାଡ଼ନ୍ତୁ ପଚାର ଦେଖିବା ଆଗ ଆପଣଙ୍କ order focus
my
on
lord, no formal communication for acceptance of the returns has been made for reopening the assessment. That is the core of the
how
issue.
can they do
And
that,
at the
sir?
core of the issue, it is can ascertain from the order.
How no formal communication, sir?
It is already settled that by this court.
I settled fine, but no formal communication wale have been
That is necessary for reopening the assessment order section.
you have not
43.
been communicated at all.
No, not at all. But so
Your lordship, for this reason, I have to call for the record, your lordship. Your lordship.
Not he's right. If you have not formally communicated, then yeah,
Again, it is covered by that order. And unfortunately, your lordship, against that confirmation of the SLP by Honorable Supreme Court, review has been filed by the department, your lordship. And that case has been posted on today, on 13th/9, before Honorable Chief Justice. That's why
9.9%
I know.
gets dismissed.
I know, but only reason is that. Only reason is that. Only reason is
refund debar thibo କିଛି ପଇସା monetary obligation ଗଡେଇବା ପାଇଁ review file କରନ୍ତି ଆମେ ଜାଣିନୁ
Tell me that the record, I have to verify the record.
let him file the record. I'll learn counsel with the state to find out the record indicating the communication, the order made by the department. One week.
Your
1 week.
lordship, 2 weeks.
2 weeks.
Because it is
Okay,
the
10th October.
Your
10th
lordship.
October.
Your lordship.
no correspondence.
So no question on the extension.
Your lordship.
Your file I, sir?
My lord.
Which I, sir? 12041.
My lord.
Your lordship, 12042. From the cost rate.
12042 last result to
42. There shall be stay of the recovery of the demand. Next. More this. Yes. Yes.
Item 11. May I please?
Item 11, your lordship, just now the copy has been sought. Just now, your lordship. Your lordship, it is against the show motor revision and against show motor revision 79(7) appeal file against that appeal order. This writ petition has been filed. Earlier, he has filed one STR review. Just now, I have received the copy.
It deserves some time. You can't say no. Did it come on 25th?
Your lordship,
25th.
your lordship. Good.
Next.
Item 12.
May I please your lordship? But here the petitioner's unit is a manufacturing and bottling unit of CL as well as the rectified spirit. Rectified spirit, my lord. Lordship, he is licensed to manufacture and bottling the CL and rectified spirit, my lord. Lordship,
What is
while,
the issue here?
lordship may see the annexure 2, page 20. While continuing as such, there was a show cause notice issued by the superintendent of.
Sir, what is the issue?
Now the demand, my lord, on
I'm
basis.
asking what is the issue?
Issue, my lord, now there is a demand has been raised on basing upon an ex-parte audit report relating to the year 2015 to 16 to 2022. Yeah. Now they have demand has been raised to
So you
18
are saying
lakhs.
that is for the year
2015 to 16 to 21 to 22, my lord, on basing upon an ex-parte audit report.
What do you mean by ex-parte audit report?
Because the audit report, they have audited the.
Is there any scope for
They have never
allowing the other
called
sides
for.
to participate in audit?
Sir, without your cooperation, how the audit will be done? Definitely they must have.
On
taken-
basing upon the report submitted by the superintendent of, because it's a bottling unit, my lord. What it does, he
bottling unit ଆପଣ କାଗଜ ପତ୍ରକୁ audit କରିବେ
Well,
ଆପଣ ଆଜିର bottle ରେ କେତେ
from
କଣ
molasses,
ପକେଇଛି?
he prepares country liquor and rectified spirit, and he is also licensed to supply the rectified spirit to HAL as well as the government hospital of the state, my lord. So this is the due they have claimed. I have used excess MGQ of molasses.
That's correct.
This they have now
Unutilized, unutilized.
unutilized କହୁଛନ୍ତି ସେମାନେ କହୁଛନ୍ତି demand raise କରୁଛନ୍ତି ମୁଁ କହୁଛି demand raise ହେଇଛି
Unutilized molasses.
molasses. Then lordship may say annexure 3 I have filed my show cause also. I have stated that whatever the stocks I have procured in that relevant year, I have used that and prepared the CL as well as the rectified spirit. And I cannot sell the CL because I will have to deposit before the Orissa State Beverage Corporation. From there, the retailer they can procure for sale, man. I have prior to that also 2019 lordship will find page 22. I have also 2019 I had approved the commissioner that this much amount of MGQ lies with me. I don't want to procure from the market because now lordship knows sugarcane production has been decreased in the state.
One more thing.
That apart, my lord, the same thing again, annexure 4 the demand they have raised. Prior to that, my lord, also may see the annexure 5 series.
Can you come to your read petition?
My lord. The annex,
Please come to paragraph 1 of your read petition.
my lord.
The molasses of excise year 2015-16 and 2021-22.
22.
But demand is from 2015-16
15 to 22.
but you have claimed only 2 years, 2 financial year.
My lord, instead of hand, it will be 2.
No, in the read, in each and every paragraph, it has been written like this.
The wrongly typography in and
You
has
have to
been.
rectify something.
Yes,
There can't be-
that will be 2. That word will be used.
From to 2.
2, my lord.
But you
my-
have used
yes,
only 2 years.
that
And one more thing that you have requested not to fix the minimum guarantee of quantity of beer
yes, yes,
in the year 2019.
19, my lord.
That means that year 1920 is also covered.
Covered.
So 15-16 to 19-20.
20.
There are 4 financial years.
15 till
15,
16. 7 years, my lord.
No. You just you listen, please. 15-16, 16-17, 17-18,
18-19,
and 19-20.
20-22. Till 22.
No. You have requested not to fix the minimum guarantee quantity in the year 2019.
Yeah.
That means you agree for fixing of minimum guarantee
Yes.
quantity up to the
19,
financial
up to
19-20.
19.
There are 5 years, 5 financial
5
years.
years.
Only 2 financial years are remaining, according to your claim.
My lord, my lord.
So still then you have to pay the, then if you
ମୁଁ କହୁଛି, let the authority consider, my lord. Because I have replied, let them consider. And they say that what the exact duty I am liable to pay. Nothing, Lordship may see, the demand notice, nothing says, only the amount they have reflected. What exact kind of excise duty is liable to pay, my lord, am I entitled to pay? They have not discussed on
So
everything.
you're basically your grievance is that you want to know what is the
Yes,
amount
exact, my lord.
Amount has been fixed as 18 lakhs something like.
18
that.
lakh, 18 lakhs.
Fix it.
My lord,
Amount they have
they
fixed it.
से fix मतलब से amount से कोड आनले केते पैसा देबी year wise केते मु यूज करछि ताकर inspection report थाय आज्ञा every unit manufacturing unit
But
has a
Sir,
excise
you
option.
must be knowing that since the audit objection has also, you must have reflected.
The Lordship may so they have not supplied me the copy also.
Is it so,
Again,
sir?
गोटे जो unit रे जो manufacturing
This has come for the first time, my lord. I will take their instruction to that effect. But before that, my lord, the order is appealable.
Order is appealable. Yes.
No, yesterday, my lord, also a
If
batch
it-
case before your lordship,
If you're
where your lordship has opined, this is a demand notice, not an order. That's why interim order has been extended. Yesterday, my lord. I'm unfortunately, I have no.
this is the order plus demand, my lord.
Six matters were there. First matter I have, yesterday it was listed, but yesterday's order has not yet been uploaded. 6 matters were there, same MGQ. That interim order there, no course of action. My lord, I am not denying that I am not liable to pay. Let them find out the what exact amount, what is the excise duty they have levied on me, my lord.
It has been
Because the
quantified as
lordship knows
18
it
lakhs,
is the
my lord.
only manufacturing unit supplying rectified speed to the hull.
Sir, if there, if the statute provides an appeal, why you have approached this?
My lord, because
authority?
this is a demand notice, my lord. This is not an order.
But demand
Yesterday, your lordship has opined, this is not an order. This is a demand notice.
This is
Order
order come demand notice, my lord.
250,
Yeah,
rule
is right.
250.
First paragraph is the order,
Rule
the
two-
second one is the demand notice.
No.
Demand.
Your lordship,
You approve that, what is the problem?
my lord, let the commissioner decide, my lord, till then I may be protected.
Why should we protect?
Because my lord is a bottling unit. Rectified
sir,
hull
ma-
ku jauchi, hull notice limited use
You
jauchi.
know how state government goes slowly.
No, my lord, more
State
predicament
government
jauchi.
goes very slowly. Till the time you go and fight
Lordship
them,
knows is
no-
a
nothing
only bottling unit having supplying the hull. Hull ରେ ତାଙ୍କର use ହଉଛି rectified.
ହାଲରେ କଣ
Lordship, I have written.
ଆପଣ କୁଆଡେ କଲୁ ଆମେରିକା
ନାଇଁ ନାଇଁ ହେଇପାରିବନି ଆଜ୍ଞା ହେଇପାରିବନି.
ଆମର କହିବା କଥା କଣ
ନାଇଁ।
ଆମେରିକା କରୁନାହାନ୍ତି ଆପଣ?
Only I am licensed to manufacture and supply. ମୁଁ ଆଜ୍ଞା directly ବିକି ପାରିବିନି କି ଦେଇ ପାରିବିନି.
I'm not on that. You may go to, you may supply to HAL or to the NASA,
Lordship-
we don't bother about that.
Lordship,
My question is, if you have
ମୁଁ
an appellate authority, just
so
go.
Lordship, I will approach because in 2019 I had approached the authority, my lord, commissioner. They have not considered it my case. Let the 2019
No,
letter-
what you have written to the commissioner in 19.3. Please see.
19.3 ମୁଁ ସେ ଯୋଉ ଆଉ MGQ ଟା ମୁଁ procure କରିବିନି, whatever the stocks with me I will utilize that, my lord. ମୁଁ ଏଟା request କରିଥିଲି,
You have requested,
my lord.
but what is your explanation that they have forced me to?
Yes, ଆଜ୍ଞା
How
ଆଜ୍ଞା
can it? How
ଆଜ୍ଞା
can it be such a
ଆଉ
plea?
ଆଉ ସୁଗାର କେନ୍ ନାହିଁ
No,
ଆଜ୍ଞା.
if somebody
ଆମର
forces,
ବଡମ୍ବାରେ ଥିଲା
Sir,
ସୁଗାର ଶକ୍ତି ସୁଗାର କ୍ଲୋଜ ହେଇଗଲା.
sir, listen, sir.
Only
If-
Aska sugar factory
Sir, yeah.
is supplying.
Just hear me, brother.
Sir,
Just hear me.
if somebody force you to do something which is not permissible, would you do?
ନା ସେଇଟା ତ ଆଜ୍ଞା
Now, what you have written in your showcase, that
Because-
only because they excise authority forced me to do, I have done it.
because ମାନେ ଆଜ୍ଞା rectify speed
As if somebody says kill X, you would kill.
that is not logic.
Your lordship will appreciate once the license is issued, MGQ is the most compulsory, my lord.
ସେଟା MGQ ଆଜ୍ଞା later on fixed ହୁଏ, ଏଥିରେ fixed ହୁଏନି. State government is authority to fix the MGQ.
You approach the
Commissioner. Commission excise, my lord, only matter till then I am protected in view of that.
within 1 week. Till then, can you?
Till then it is not possible because how can you
You
assume
can
the
ask for that. You file it quickly.
Lordship knows commissioner ମୁଁ ଆଜ୍ଞା excise case କରି ଯାଉଛି ଆଜ୍ଞା କିଛି ଦେବେନି ଆଜ୍ଞା ଆପଣଙ୍କ ବ୍ୟତୀତ ସେମାନେ କିଛି ଶୁଣିବେନି ଆଜ୍ଞା. Because I have last 15 years experience.
Sir, how can we protect you
Because
in
lordship,
appeal?
lordship's order is there.
No.
Yesterday lordship has extended that order. MGQ same matter. ମୁଁ କହୁଛି ଆଜ୍ଞା ଗୋଟେ ନହେଲେ ତାକୁ ଅଣା ଯାଉଛି କଣ exact amount କଣ
No,
ଅଣା
that is, I will not on that point because you are seeking for interim protection
Only
in the
protection.
appellate.
ଗୋଟେ ମୁଁ appeal
Appellate
file
authority.
କରିବି.
How can this court would pass an interim order in appeal, which is not in existence?
Prima facie lordship knows that this is a running unit. I am licensed. I am paying the 25
you
lakhs
can-
license fee.
You can approach the appellate authority for interim protection.
ସେ ଆଜ୍ଞା ଦେବେନି ମୁଁ ଯେତିକି ଏକ୍ସପିରିଏନ୍ସ ଅଛି ମୋତେ
Sir.
ଟୋଟାଲ ଦେବେନି ଆଜ୍ଞା. ହାଇକୋର୍ଟ ପଠେଇଛନ୍ତି ମାନେ ସେ ଟୋଟାଲ ଦେବେନି ଆଜ୍ଞା. ସେ ଯେ ଲାଷ୍ଟ ଅର୍ଡର ୟୁ ଲର୍ଡସିପ ହାଜ ସିନ୍ ଦ୍ୟାଟ୍ ଅର୍ଡର. କାଲି 12 ତାରିଖ ଥିଲା 6ଟା ଯାଇଛି ସେଟା ଆଜ୍ଞା posted to 11th October.
But I don't know what are the order yesterday.
I have downloaded
This
yellow.
order not passed.
No, yellow. Yesterday before Lordship, 6 cases. My friend
I
Procureur
don't
who was
remember that.
arguing that matter.
I don't remember.
Yes.
that.
ଏଟା 11 ଅକ୍ଟୋବର କୁ ଯାଇଛି କାଉଣ୍ଟର ଦେବା ପାଇଁ ସେମ୍ ଇସ୍ୟୁରେ।
You better approach the.
I will approach my lord। ମାନେ only board ରହୁଛି ମତେ ରନିଂ ୟୁନିଟ ଆଜ୍ଞା ଆମର ଇଏ
କିଛି
ହେଇଯିବ
ହବନି ଭାଇ।
ଆଜ୍ଞା ସେ ମୁଁ ଜାଣିଛି ମୁଁ ଆଜ୍ଞା ଏକ୍ସାଇଜ ଅଥରିଟି ଜାଣିଛି ନା ସେମାନେ
My lord may observe to consider the commissioner to consider his interim.
on filing they'll grant the intimate so that
No, how can you pass that? On filing, you will be protected by way
ଆଜ୍ଞା
of.
ଗୋଟେ ମାସ
It is to be considered.
ନମ୍ବର କରିକି କେସ୍ ନୋଟିସ ଦେଲା ବେଳକୁ ଗୋଟେ ମାସ ଲାଗୁଛି ତାଙ୍କୁ ଆଜ୍ଞା।
ସାର୍ ଶୁଣନ୍ତୁ ଗୋଟେ କଥା କୋଉଠି ସେଠି
ଆଜ୍ଞା କମିଶନ ଭୁବନେଶ୍ୱର ଆଗରୁ ଥିଲା କଟକରେ ଏବେ now shifted।
ମୁଁ କହୁଛି ତାକୁ within 1 week will pass order then.
ମା ଠିକ
Your problem sir. Demand notice number 1 every pressure order is support it is a violation of business and the calculation of the during the utilization balance and the allowed the manufacturer of and his constant dispute. For the submitted, since the fixers unit is what we mean in the district report. And license to begin the country of molasses. What is the appeal section?
appeal is
Section 6, read with rule 250.
no only rule 251
250.
of Orissa Excise Rule 2017 collector commissioner data no commissioner MGQ commissioner
Orissa Excise Rules 2008 na?
17
17.
Rule 251
shall consider interim within 1 week filing. They'll hear it within 1 week. Give the
ଆଗରୁ ଥିଲା ଆମର ସତୀ ଚୌରା ପାଖରେ ଏକ୍ସାଇଜ ଅଫିସ ଟା now it has shifted to Bhubaneswar and designated as a camp court କରିଦେଇଛନ୍ତି
Daily communication.
ଆମକୁ ସୁବିଧା ହଉଥିଲା ଆମେ ଡିଜାଇନ କରିଦଉଥିଲୁ ଅଫିସ ଟା
ସବୁ ସୁବିଧା ହବ ବୋଲି ମାନେ
ଏବେ conveyance ଟା ଅଧିକା ନେବେ।
No, you will get extra fees for their.
Outstation charges.
ଏମାନେ ଫିସ୍ କଣ ଦେବେନି ଯାହା ହେଲେ ଦେବେ କଣ ବିଲ୍ ରେଜ କରିବା କଥା ଖାଲି
ହଁ ଆଜ୍ଞା
it's not a common litigant. Okay, next.
My friend will get outstation charges.
Outstation charge, correct.
Item number
urgent copy
lunch break रे नहीं जी lunch break रे आज ही जाके फाइल कर दो अपन पाके रेडीमेड थे मैं जानी कंप्यूटर गले खाली चेंज कर दे चिपक संगे संग फाइल next
item 13
So this is for restoration. What happened? What is the I mean ground for your seeking restoration? Okay, we are restoring. Let's hear it. Hear it, merit on. We are restoring, sir. We are on now. Are we on the merit? Restoration दिन नहीं ସେଇ ଦିନ ସାଙ୍ଗେ ସାଙ୍ଗେ ଆର୍ଗ୍ୟୁ କରିବି ଆପଣ ରେଜିଷ୍ଟର କରି ପାରୁଛନ୍ତି ମେରିଟ ଆର୍ଗ୍ୟୁ କରିବି କାଲି ଏକା ସାଙ୍ଗେ ନବା ତାହେଲେ adjourn to tomorrow ଆପଣ ରେଡି ହେଇକି ଆସିବେ କାଲି ନେବ
May I pray, my lord? As my lord Satapathy was sitting with Chief Justice at that time, that's why the matter has come.
ठीक है जी, that we are not disputing that.
My lord. And
we are not saying no, we are restoring it. Only thing is to argue.
But writ appeal will be heard by, if your lordship will hear it.
Why not? His brother is there. The writ appeal will change him. Wherever he is, they will change him. What is the problem?
My lord.
So we can hear it.
My lord.
Very small issues. Allotment of a shop room in favor of a government servant, which is not permissible because government servant are not permitted to do business. He was a government servant. What it appears from the impugn order.
You get it tomorrow.
And the party has intended to transfer the shop room in favor of his wife. That is the whole issue.
So we are not restoring it now. Tomorrow we'll restore and also hear it. Final. Okay? Get ready.
Because but we are not assignment 9. It is not within our assignment. Probably it is not within our assignment.
No, let's do one. We are restoring it and let it be placed before the Chief Justice to give the appropriate assignment, right? Yes, we are restoring it. Next.
Item 14.
May I please.
Dear my lords, I am appealing for the respondent.
14.
Item 14, my lords. My lords, I think Mr.
It is
Mishra
the
has
state
already.
revision. No, not completed. Your lordship, yesterday I have just started. Your lordship, it is my state revision.
Okay.
State revision, your lordship.
Okay, very good. Continue.
Let me complete, your lordship. Yesterday,
Before that,
your lordship.
you have filed your reply, sir.
No, I have not filed. I'll file.
File a reply, then we will
Yes.
hear it finally.
Yes.
No point unnecessary.
Your lordship, it is a,
hearing in part.
it is a revision petition, your lordship.
Maybe,
Reply
but
may
I
not
have
be
also
required.
got the, yes. I have got
No, so far as written reply counter, your lordship. may not be-
I'll file a small objection. Why you are,
We are in the habit of
denying.
saying.
Why you are
counter
block-
written done, na? That's
why you
why.
are so much afraid?
Sir, do one thing, sir.
I'm always afraid of your
give me a
lordship.
short-
Your senior, my
I'll
lord
tell
and
you.
senior.
Let's hear it.
I'll-
Your lordship,
When 21st.
your lordship,
Can it be a malus 22nd?
22nd.
Yes,
your lordship.
22nd.
obliged.
A small issue, sir.
Your
Yes,
lordship.
Can be easily,
Whether it comes
we'll finish.
within the tax-free list
Yes.
or it is on the taxable list.
Item 15.
15.
May-
15 and 22 are the same issues. Notice has been issued, but the lordship has to formulate the question of law.
So, who is appealing for? You are appealing?
Same 22 and 15 are the same issues and one family.
Okay. Let's.
So it,
The petition. Appellant. The appellant challenges the order passed by High Income tax, revenue, total bench. Order debtor,
Six, 7, 2022.
First line लेखन देने ना problem.
Again.
इधर सब लोग तो डेट लगा. Number लिख ले सब लिख ले डेट चाहिए.
Yeah.
Order debtor. 6/7/2020. Passed in IT number 213/CTK/2019. Very nice. Full stop. Good. The respondent has filed the present is appeal. Question the legal order passed by the High Court and he has framed the following questions, substantial question of law. First, whether the only one person. First one, first of all, under the long-term capital limits on sale of shares obtaining
A and B, because whether it is
Whether B is
because there is a rider in the 1330, whether it is been recognized stock as through the sale through recognized stock exchange.
Maybe both.
Yes, both are.
Yes, correct. So let's the matter on. You filed a written submission.
My lord,
Any
item 22,
inhibition?
I'm appearing for item 22, which is another one.
Item 15. Same.
So I'll take instruction whether.
I'll short copy, extra copy.
Give a copy. I think file a written submission.
Yes, my lord.
Let's fix.
Actually,
Let's
there
fix
is
the
no
final
substantial question of law arises.
Huh?
Actually, there is no substantial
Sir,
question.
we'll see that, sir.
Okay.
You are framing just now.
Yes.
We'll see that if there is a substantial question is there or not, we'll see that. We'll examine. And with the matter pertaining to 2016, so we have to finish it. This is the matter for final hearing on 27.
22.
I tell
Huh?
22 matter.
22 matter.
What?
22.
Yes.
But
That is tribunal.
Tribunal order.
tribunal order I'm saying.
Tribunal.
I'm saying tribunal order.
Tribunal passed on 6/7/2022.
22.
Yes,
but-
relating to your assessment.
That's why I'm saying, year of assessment 2016. କେତେ ବର୍ଷ ଆମେ ଖାଲି କୋର୍ଟରେ ରହିଲାଣି କେତେ ବର୍ଷ ସେଇଟା କହୁଛୁ. It might have come to
yes.
6 year tribunal. Now we should not keep it for another 6 years in High Court.
ଏବେ ଆଉ ନାହିଁ ଏବେ ଆସିଗଲାଣି ମାନେ 21 ଆସିଗଲାଣି ଆଉ ନାହିଁ
କେତେ total ଅଛି?
ଆଉ ବେଶୀ ନାହିଁ 100-150 ଥିବ କି ନାହିଁ
ଆମେ
ସଫା
ସଫା
ହେଇଗଲାଣି ଏତେ ସାରିଦେଲା ଆମର କିଛି କେସ୍ ରହିବନି
ବାକି ଯୋଉ ଟ୍ରକ୍ ଲୋଡ୍ ଯିବ ସେଠିକି ସେଠୁ ଯେ ଆସିବ ସେଟା ରହିବ ତାପରେ ନୂଆ ହବ ଆଉ ଯିବନି କି?
ନାଇଁ ଏଗୁଡା ଯିବାର ନାହିଁ କୁଆଡେ
ନା ନା
ଏଇ ଇନକମ୍ ଟ୍ୟାକ୍ସ
I'm saying the tax matter, I'm
yes.
saying, not income tax service. ଗୋଟେ ଟ୍ରକ୍ ଲୋଡ୍ ଯିବ ନା
ହଁ ଟ୍ରାଇବୁନାଲ କୁ ଯିବ
ଟ୍ରକ୍ ଲୋଡ୍ ଯୋଉ ଫେର ଆସିବ
ପୁଣି
ସେଠି।
ଆସିବ
ହଁ ସେଇଟା ତାପରେ ଜମା ହବ ଆଉ। So କେବେ କରିବା? 26
next October yes
so 10th October 9th October
9 October yes
for final hearing.
yes
You get ready, sir. Give him a copy.
15 and 22 both no
Next
Item 16.
16.
May it please your lordship. Your lordship, in absence of the GST tribunal, the petitioner has challenged the order of the first appellate authority.
Delay. There is a delay.
Delay, but my learned friend is yet to serve a counter. So it is a second round. My learned friend is yet to serve a counter upon
Non-functional tribunal matter.
tribunal matter.
Yeah. You are for the
Petitioner.
okay. You have to
State GST.
you file a reply.
File a reply.
Same order. So order, give me the order copy. Put it in.
No, it has been already been passed the second round.
Oh, acha. Sorry. Simply you just modify the reply.
Oblique.
I thought first time. Anyway.
Item 17.
Item 17 on behalf of Mr. James Patnaik, my lord.
Sorry?
On behalf of Mr. James Patnaik, petitioner.
Again, you'll take time.
My lord.
Time
Interim order. Interim order is there.
Entry mode छोड़ देबे समस्त दौड़ी दौड़ी आसी दौड़ी
Next
जोइसी
week, next
हां
week. Lord,
हॉस्पिटल रे दौड़ी आसी
He's suffering of
किसी हॉस्पिटल न थांती सर आउ को फोरम रे थिबे
No, no, my lord.
हां हां हमें जाननु
I am also suffering
मु
of fever, my
बहुत मु
lord.
देखु हां किछि नहीं सब list the matter for final hearing
Yes, ma'am.
4th October
Already in this case, I have
ready is na
4th October. Yes, ma'am.
ready
ready, ma'am.
building complete final hearing 4th October keep the matter for final hearing on 4th October and no further time shall be granted to any of the party. Next.
Already in this case, I
Interim
have
order.
highly replied to rejoinder. That has not come. Lordship may direct.
Not come means?
No, that has not been
Record actually. Check kar do. Rest to find out.
reply to rejoinder filed by the department.
Yes. Agent file. कब file कर सिले?
That has been filed on 29th August, my lord. 29, yes, ma'am.
29 August. Rest to verify.
Interim order to be continued next
You
day.
want to continue to that.
Obliged.
Obliged, ma'am.
Next.
Item 18.
May I please, your lords? My lord, in this writ application, I have challenged the penalty notice issued under section 271D for contravention of provisions of 269S of the Income Tax Act. They have issued the input notice, both Joint Commission of Income Tax as well as the Income Tax Officer. For
The ITAT order is, what is the ITAT order?
No, here you are challenging notice.
Notice.
After assessment order was passed, penal provision has been issued, the notice has been challenged.
Annexure 14 is the notice issued by the Joint Commission of Running Pay 7.
Again?
Would have gone to ITAT.
No, he has to participate in the proceeding. He has not participated. He challenged the notice.
But he has filed some ITAT.
No.
That is a
blessing of my lord.
Oh, sorry. Assessment order, sorry.
No, I am blessing that tax. Before going to the merit of the case, your lordship may kind of say annexure 8.
Annexure?
8.
8.
It is the second round of litigation. Your lordship find it page 47. Order dated 14/3/2016.
Yes.
Your lordship find?
Yes.
Mr. R. Mr. Ekera, Lineage Counsel for the petitioner, and Mr. Acharya, Lineage Senior Standing Counsel for the Income Tax Department. We take upon necessary educate him to note that facts and circumstances present case that the petitioner was originally assessed under section 143(3) of the Income Tax Act for the earlier period 2008-11 under Annexure 1 dated 8/28/2013. Thereafter, notice dated 16/1/2015 Annexure
148 notice.
Came to be issued by the department reopening the case of the petitioner for the aforesaid period. Pursuant to the said proceedings under Annexure 148, the petitioner violated dated 30th January 2015 Annexure 3 sought for reasons for reopening, and the same was responded by the department by letter dated 7/4/2015 Annexure 3. Tenant counsel for the petitioner submitted on receipt of such response by the Annexure 4. He filed his objection under Annexure 5 and 7. He further contended that objection raised by the petitioner have not been dealt by the assessing officer by a speaking order, and instead of assessing officer seeks to proceed the matter and conclude the same without dealing with the issue raised by the petitioner in the objection of petitioner. Reliance is made by the petitioner on the judgment of the Honorable Supreme Court, G.K. Drive Sat India Limited versus Income Tax Officer and others, reported 2003-259 IPR, page 19, Supreme Court. We see no justifiable reasons to interfere the order under challenge. However, we clarified that when a notice under Section 148 Act is issued, the proper course of action is to file a return if so desires to seek reasons for issuing notice. The assessing officer is bound to furnish the reasons within a reasonable time. On receipt of the reasons, the notice is entitled by objection to issuance of notice, and the assessing officer is bound to dispose of the same by passing a speaking order in the instance case, as the reasons have been disclosed in the proceedings. The assessing officer has to dispose of the objection if filed by a speaking order before proceeding with assessment in respect to aforesaid 5 assessment. The Acharya Ladan Council, Standing Council for the Income Tax Department, submits that assessing officer is bound by the directive issued by the Supreme Court and consequently will not proceed without passing a speaking order on the objection raised in the petitioner. In view of such conditions, we dispose of the writ petition with direction to the opposite party, assessing officer, to pass a speaking order disposing of the petitioner's objection before proceeding with respect to notice under section 140 of the income tax. Petitioner is directed to appear with
What happened after this?
Then I will come. After this order, I participate before the income tax officer.
Yes.
I submitted the objections to the reasons recorded by him. On the two grounds. One, there has been no escapement. Only if there is an escapement of income, then section 148 can be invoked. Section 147 read with section 148 can be invoked. Secondly, the loans which has been given by cash does not come within the purview of income. It is a loans and deposits. Then third is a mandatory provision is there. A notice under section 143(2) has to be served on the assessee after 148 notice. So these objections have not been dealt with by the income tax officer. Then after direction of this honorable court, your lordship may kindly see. Your lordship may kindly say annexed to 10, running page 54.
Yes.
Your lordship see, this is a parawise comment submitted to the Standing Council of the Income Tax Department. Para 1, reply to para 1, no comments. Para 2, no comments. Para 3, no comments. These are the reasons recorded by him. As if this is the parawise comments to the Standing Council of the Income Tax Department. But he has not disposed of the objections raised by the assessee petitioner.
Where is that paragraph where objection has been dealt with?
Yes, ma'am. Your lordship may kindly say annexure 5, running page 30.
Annexure. Running page?
Running page 38.
38. Yes.
May I please enter?
Yes.
That pursuant to the request of the assessee, your honor has been pleased to communicate the reason for reopening the assessment under section 147 Income Tax Act 1961. Hereinafter referred to as the Act for the assessment of 2010-11. The assessee now submit the following objection to your reasons recorded in the above mentioned letter dated Arkansas dated 7th April 2015 as follows. That in the instance case, the assessment is completed under section 143(3) on 28/1/2013 by disallowing the claim of assessee under section 81(b)(10) of the Income Tax Act and also further disallowing expenses under section 40A IEA and 48(3) of the Act. During the course of assessment proceedings, notice were issued from time to time to which the assessee had complied, and thereafter the final assessment order was passed. That your honor in the above mentioned later refer the reasons for reopening case and gist of the reasons are as customer advance 1,31,57,000 was received from 7 customers in cash for the ensuing assessment year which contravenes the provisions of section 269 SS and attracts penalty under section 271D of the Act. The case is reopened under section 147 examination sought like found out by the audit party. On the basis of the following two findings, Your Honor, is that the opinion that there is an escapement of income and the reopened case under section 147 of the Act and issued notice under section that referring to the above findings, the assessee now submits the objection to both the points as well. That at the first point, you pointed to the assessee has received the customer's advance in cash in excess of 20,000, which contravenes the provisions of section 269.
What is your answer to this, sir?
Yes, sir.
What is your answer to the 269 contravention?
They have answered, sir.
Yeah.
For this observation submitted that assessee might have received the customer's advance cash, but there is no escapement of income. It may attract the penalty provisions in section 270 certain circumstances, but not with tax as income. Further, Your Honor may appreciate that income and penalty both are different provisions and cannot be equated in the same light. Therefore, Your Honor is under wrong surmise and escapement of income is found out before initiating the assessment proceedings under section 147 and the proceedings initiated under section 148 is illegal and to be dropped for the interest of justice. Okay. That is bring to your kind notice that section 269 SS Act, which is covered under chapter 20B of the Act, begins with requirement to be made acceptance, payment, repayment in certain cases to counteracted evasion of tax. Hence, we would like to bring to your kind attention of Your Honor that the terms certain cases and terms evasion of tax differ in important aspects, which will determine whether there is a violation of provision section 269 Act or not. From the above creation, clear that intents of legislation levy penalty on certain transactions will involve tax evasion, not to restrict the genuine transaction and to punish the bona fide. In the instance where the amount shown by the assessee has been shown by the customer in their books of accounts, which are verified by the lending assessor at the time of assessment. Therefore, there is no evasion of tax and no penalty. Proceedings can be initiated. The finding relied on the ratio such and such. That without prejudice to the submissions made in here and above, it is indicated that legislature by intent proposed to make the amendment in the provisions of 269 SS by the Finance Act 250 and the comparison the existing provisions and proposed provisions as follows. Existing provision, no person shall after 30th June 1984 take or accept from any other persons herein referred section referred to as a depositor any loan or deposit otherwise than by account by check or account by draft or used by electronic clearing system or bank account if the amount of such loan or deposit 20,000 rupees or more. Proposed provisions. No person shall take or accept any other person hereinafter referred to as the depositor any loan or deposit any specified sum otherwise than by an account by check or account by draft or used by electronic clearing system through bank account if the amount is 20,000 rupees or more. By comparing the both the provisions, it is clear that what any specified amount have been proposed to be inserted newly and the word any specified sum has been defined in clause IV to explain some section 269 SS as specified sum means any sum money receivable whether as advance or otherwise in a relation to transfer of immovable property, whether on transfer takes place. From the appreciation of the above two comparison takes place, the explanation is clear that earlier the advances received from customers in cash or for transfer envelope are not violated the provisions of section 269 SS. As this amendment is proposed to applicable from 1/6/2050, and this amendment is proposed that therefore in the instant case the assessee has not violated any provisions of section 269 SS. More so, there is no short levy of tax penalty. For your kind perusal here, we are enclosing the relevant pages of budget book 2015. Yes.
What is it?
He has not challenged the assessment order has been completed. He has not challenged the order of assessment. He has challenged the notice issued under section 271D on violation 269. So therefore 269 is. So there is no grievance. So whatever now is placing, it has already been complied with by passing an order of assessment. He has not challenged the order of assessment. in any forum. He has stated in last order, your lordship see. Now his grievance is the issuance of notice is not permissible.
Is without written barred by limitation.
That is what is
I'm
late.
submitting. I'm just still complete. I will submit. Why I have not challenged the system?
It is the earlier what a submission that is not now in a position to answer your lordship because it has only completed. Assessment has been passed. Thereafter penal proceeding initiated. So only the issue is whether the notice is permissible or not. He has not participated in the proceeding because of lordship interim order. That is the issue has to be adjudicated here.
May I please?
Yes.
Your lordship may kindly see Annex 12. This is an order of assessment under section 144 and 147 of the Act.
Yes.
Your lordship find?
Yes.
Page 71. They have assessed total income 44,56,750. Just for the moment, your lordship may kindly see Annexure 1.
Annexure 1.
Running page
Sir,
32.
27.
No, running page 32. My relevant portion.
Oh, relevant person.
Yes, madam. Your lordship find?
Yes.
Your lordship may kindly see the total income is the same. 44,56,750.
Yes.
So there is no same, there is no escapement of income. In the original assessment, the quantum fixed remains the same in the reopening assessment. So there is no scope of challenging the reassessment order. Demand is the same. And for 5 years past the order, your lordship, there is a limitation.
Now, after how many years it is there?
I think he has passed the order.
After?
Your lordship, this is assessment year.
This is assessment year
19. Original assessment was completed.
And that notice is on?
Notice is on 31st March 2013.
You can't just change somebody first. This is a long time. You have a limitation for that.
No. The original assessment are passed. Thereafter, by virtue of this honorable court order.
Gap between the two.
No, there is no. So, but as a limitation, you have to calculate by the assessment order passed subsequently 147 by virtue of lordship's order.
That I know.
So now the question is, he's challenging the penal proceeding penalty notice issued under the assessment has nothing to do it in this case because he has already. Because the question is whether the penalty notice issued under Annexure 13 is permissible or not. That your lordship has to see. Kindly see the Annexure 13, running page 74, and vis-a-vis the 271D of the Income Tax Act. Lordship, kindly have a glance at that first.
74.
Page 74.
14.
Yes.
Assessment proceeding assessment 1011 appears me to you that you have taken or accepted a loan deposit contraventions provision of section 269 SS. Then your lordship, please see page 68.
68.
Yes. Sorry, page 65. There is a chart.
Yes.
Para 2.2. The detailed amount received by the assessee and classified it under the accounting head advance received from the customers. And all are the cash. Then your lordship see 269 SS. This section.
Page
269 section. Income Tax Act. Chapter XXB. The heading is mode of taking or accepting certain loan deposit and specified sum.
269,
Double S.
Capital S.
You're skipping all this thing. Kindly see section subclass C.
Yes.
The amount or aggregate amount referred in clause A together with the amount of aggregate amount referred in clause B is 20,000 rupees or more. So all this amount is cash deposit is more than the 20,000. So therefore, the penal provision of section 271, then your lordship 271D. Yes. If a person take or accept any loan or deposit in contravention of the provision of 269 SS, he is liable to pay by way of penalty sum equal to the amount of the loan deposit. So taken or accepted penalty shall be imposed and joint commission shown. So now, in view of the section 269 contravention, 271D has been issued, and it has been reflected in table 2.2. So therefore, there is, if there is any grievance, he may participate and explain. So this is illegal. The notice is without jurisdiction. Let him say. If there is an order, then he is approach this court or whatever the.
Your lordship may kindly see.
That is the issue, my lord. Core issue is that.
Lordship, in this case.
Yes.
Another notice, your lordship may kindly see. Annexure 14, page 75.
40. Is it 14?
Page 75.
Yes.
For same cause, for same assessment order, another notice has been issued by the Joint Commission. Annexure 13 was issued by the income tax officer. Then another notice has been issued by the Joint Commission for same cause, for same assessment here. Just what?
Yes.
You know what's it? Why he has passed the 148 order when there is no escapement of income, only for revival of the limitations. Your lordship may kindly see section 275, subsection C of the Income Tax Act. Lordship, fine?
Yes.
275C.
Yes.
In any other case, here the 2751, if I feel is preferred, this is all are there. In any other case, after the expiry of the financial year in which the proceedings course of which action of imposition of penalty has been initiated are completed for 6 months from the end of the month in which action for imposition is penalty is initiated, whichever period expires later. So my lord, only submission is if the assessment order passed under section 148 only for the purpose of revival of the limitation for initiation of proceedings under section 271D for contravention of the provisions of 269S of the Act. So it is a bar by limitation, having no jurisdiction.
Okay.
Yes.
Yes, sir. What are you?
So far as the second notice is concerned, this is a change of jurisdiction. Lordship, see the notice of hearing.
Change of jurisdiction.
Change of what? Now 75, page 70, which has been pointed out. Annexure 14. Issued by the Joint Commissioner because corporate assessee has been subsequently changed the jurisdiction. So it is a continuous notice has been passed within time. So therefore,
this is the change. I mean, this is
jurisdiction of changing of internal administrative purpose that has been changed. So that
just after 3 days.
Maybe 1 day, whatever. That is not like your lordship change the rotation of the. That cannot question the limitation because once notice has issued, the limitation start from that day. That is a settled principle law, Your Lordship.
Next.
Item 19. 19, my lord, I am challenging an order of the Income Tax Department fixing the rate of TDS at 0.3% on the ground that this is in relation to an agreement between the petitioner and one Hindustan Unilever Limited, my lord. On the ground, I am challenging this on the ground that the agreement between Hindustan Unilever Limited and the petitioner is purely a purchase agreement and is not a works contract. Therefore, is exempted from TDS under the explanation to Section 194C of the Income Tax Act. Second, while I had represented for a lower income tax nil in TDS, they have passed order under Section 197 fixing it at 0.3% without assigning any reasons.
So you are saying it should be nil.
Yes, my lord, it should be nil. Lordship, may kindly see the agreement first.
The purchase agreement entered into by the party, this is the seller. You are the
Yes,
seller.
I am the seller, my lord. As per the dossier of Hindustan Unilever Limited, I buy certain materials from other sources, not from Hindustan Unilever Limited, and I manufacture certain products as per the specifications of Hindustan Unilever Limited, and they buy it from me. It is a sale purchase agreement, my lord. Annexure 1, page 41, my lord.
So basically, it's an agreement to
For-
supply.
Not
Purchase agreement.
a purchase agreement. Yes, my lord.
Purchase agreement. You are supplying.
Yes.
Yeah.
I am selling, my lord.
Supplying.
My lord, your
You're
lordship.
selling.
Selling, my lord.
Okay, selling.
Your lordship, may kindly see the agreement at page 41, my lord.
Yes.
Hindustan Unilever Limited purchasing agreement. Hindustan Unilever Limited is the buyer. Oriclean is the seller. Page 42. Clause 3, my lord. Pursuant to discussions between the buyer.
Clause 3. What is clause 3?
Your lordship, I'm sorry, my lord. Your lordship is, my lord, I'm holding 30312 of 2020. There are two writ applications.
35140.
Well, the first one, 30312. There are two writ applications.
What is your grievance?
My lord, I should be exempted from TDS. I should be exempted from TDS in view of the provisions of Section 194C. Lordship, may kindly say I will place only 194C, my lord.
Read it.
Payment to contractors, 194C. Any person responsible for paying any sum to any resident hereinafter in this section referred to as the contractor for carrying out any work, including supply of labor or carrying out any work in pursuance of a contract between the contractor and a specified person shall at the time of credit of such sum to the account of the contractor or at the time of any payment thereof in cash or by issue of a check or draft or by any other mode, whichever is earlier, deduct an amount equal to, my lord, whatever it says, my lord. Then after the proviso, my lord, there is an explanation for the purpose of this section. Yes, my lord. Here, your lordship may kindly see explanation for the purpose of this section. Lordship may kindly see Roman 4. Work shall include A. Advertising, B. Broadcasting and telecasting, including production of programs for such broadcasting or telecasting, carriage of goods or passengers by any mode of transport other than railways, catering. E. Manufacturing or supplying a product according to the requirement or specification of a customer by using material purchased from such customer. Then your lordship may kindly see, but does not include manufacturing or supplying a product according to the requirement or specification of a customer by using material purchased from a person other than such customer.
Just a minute.
My lord.
The, actually, actually what, easy wash bulk powder
Yes, my lord.
to use, supply to the petitioner,
Yes, my lord.
which was required to be further processed by the petitioner,
My lord.
right?
My lord.
By addition of the raw material procured,
Yes, my lord.
some addition is there
Yes, my lord.
from, and if that procured from other sources, markets to local market,
my lord.
right? For manufacturing of the finished products.
Yes, my lord. My lord.
So, how do you explain that?
My lord, I get the raw materials from other sources. Even I get some raw material from Hindustan Unilever Limited. Your lordship may kindly see 5.6 of my page 46.
So your clause 5.6 of that purchasing agreement.
Yes, my lord.
Does it,
Says that will be an independent agreement, my lord. That will be an independent agreement. Your lordship may kindly see.
this is the agreement that is governing the.
No. Your
transaction.
lordship, if I buy anything from HUL, any raw material from HUL, that will be on independent terms and conditions. If your lordship could see, if the supplier, 5.6, my lord, last 3 lines. If the supplier of ingredients and components is the buyer, they shall be supplied on such terms as are agreed by both parties in writing and on independent commercial terms, my lord. So, my lord, whatever, my lord, TDS, that will be a different contract, my lord, completely different contract. It is not on this, my lord. If your lordship could see again the explanation issued by the government, my lord, at page 76.
So that the whatever your addition or whatever you are taking, is it not coming under the definition of work?
No, my lord. As far as that independent agreement, that will be executed, my lord. That independent
It's not in the composite agreement?
Not composite, my lord. It clearly says that it will be on independent terms.
Yes, what do you say?
Appear for OP4, my lords, in the first state petition. I am Hindustan Unilever. So, my lords, this transaction has accrued between the buyer and the seller, my lords. I procure the finished products from the seller, my lords. But, my lords, prior to 2019.
But question is, this finished product is not it's just question of buying and selling only.
Absolutely, my lords.
Because there are some additions,
Yes, my lord.
something is taking place in between.
Yes, my lord.
And because of that, it comes from the definition of work.
That's correct. My lord. Even there is a similar ruling by Madras High Court, my lords, a division bench also. What is the relevant fact here is that, my lords, my learned friend's client was procuring all the raw materials from independent sources when supplying the finished products to me. But in 2019, I undertook an assessment, and based on the assessment, I supplied easy wash bulk powder to him.
On an independent terms and conditions.
My lords,
Another contract.
I supplied that to him, and I raised an invoice that I am supplying this to you, you pay it to me, and then you raise that same product, use it in the component, and make a finished product. Without supplying that easy wash bulk powder, the finished product cannot be made out. It is a very, very essential ingredient.
Definitely, that's what I'm saying. So you have to add some, without some addition, it can't be. So addition means there's work.
And based on that, my lords, I raised an invoice and that he paid it to me. And what my learned friend relies upon 5.6 later part of that clause, my lords. There is no written agreement per se between me and him, my lords.
That's why he always is saying that different agreement,
accordingly,
there is one agreement, composite agreement.
It says on independent terms and conditions.
No, where is that independent terms and condition? That says, but you have this agreement only. You don't have any other agreement.
And my lord, that was not the reason for the income tax department to fix this rate of TDS.
So what is the reason then?
No reasons.
This is the reason, sir.
No reason has been
Yes,
assigned.
this is the reason.
Your lordship may kindly
Because
say
it comes in work.
no reason has been assigned.
In addition to that, my lord, in his own statement, page 80, lordship kindly have a glance. In corner 13, he has himself submitted that it is a vast contract. And also that is covered under 194C.
That is automatically works. You can't say that I am just simply I was supplying. You are doing some addition. That is
no, my lord. That is with regard to only one product. On independent, I manufacture many products, my lord. Not only one easy bulk.
That product will be escaped.
Your lordship may kindly see the explanatory note, my lord. First, your lordship may kindly see page 77, your lordship may for a
I
moment.
don't find anything wrong.
My lord,
Department
they have not
rightly
assigned any
deducted the
reasons.
TDS.
My lord, they have not assigned any reasons for that.
They might not have extended reason, but this is the reason.
Even if it falls
It comes under your agreement.
My lord, they have not assigned that reason. Your lordship may kindly say, I have also placed before your lordship one judgment.
The judgment.
Two citations, list of judgments I have placed before your lordship. The second one dated 29/2021.
This is government of Andhra Pradesh.
No, my lord, this is Bentley, Nevada versus Income Tax Officer, Delhi High Court, my lord.
This is only two judgments you have given me. That is, one is Commissioner of Income Tax, Tumudam.
My lords, I am relying on the judgment that it says that when I am supplying a product and based on that product you are utilizing it, 194C does not have explicit mention, and therefore, my lord, this judgment is saying that it should be falling under 194C, and by virtue of that, I have deducted the TDS and I have deposited the TDS in the PAN number of that money. There is no revenue loss caused to the petitioner per se. But however, even if he is entitled for a nil deduction, 201 provision is there. He filed a application for that. It is a discretion upon the income tax officer, my lords, to give a nil deduction.
He is for HUL, my lord. Whatever the income tax department will say, he will do it. It is doing on behalf of the department.
It's a provision
Only,
of law.
only
He's supporting.
It's a provision of law that I am giving.
Only for
No, he's just trying to say what is the provision of law. He's not supporting.
My lord, my lord, I will only place one judgment, my lord. Page 69 of my two.
Okay. What is it? Just come to the straight to the paragraph. Pick paragraph.
Bentley, Nevada LLC versus Income Tax Officer. Lord, I have filed paragraph 31, my lord.
Yes,
31 and 32. May I read, my lord? That there have to be proper reasons for the order under section 197 of the Act has also been emphasized in McKinsey and Company Inc. versus Union of India Supra. In that case, the AO determined the withholding percentage of TDS at 15% for financial year 9-10, which was much higher than the rate determined by the CIT for the earlier years, assessment year 2007-8 to 9-10 at 1.5% and 1.3%. While setting aside the order of AO, it was observed by the Bombay High Court. This was the judgment has been quoted, and your lordship may now go to para 32. The court accordingly finds that in the present case, the impugned withholding certificate, which directs TDS to be deducted at 5% on the payments made by the Indian entities to the petitioner, is unsustainable in law, in as much as it is not based on valid reasons and is contrary to the legal requirements spelled out in section 197(1) of the Act, read with rule 28AA of the rules. The impugned certificate is hereby quashed. So it is a legal requirement to assign the reasons, my lord. That is why your lordship may kindly see the last
They have
order.
not assigned the reason.
Last order.
No,
They have not assigned the reasons. They have
Come to
not
that.
assigned any reasons.
Come to that.
Page 79. Page 79, 77, my application of lordship and
77.
77 under form 30.
Which page that's
Page 77, my lord, of my REIT application, my lord.
Yes.
Form 13, I applied this for nil deduction, my lord. At page 78, I have applied.
This is this online.
Yes, my lord. Yes, my lord. Then annexure 4, my lord. This is the order fixing 0.30. I again applied at page 80, my lord.
No, this part is fine. But you are saying
No reasons, my lord. No reason has ever been communicated to me. In fact, when I applied again a representation at page 83, they dispose it off at page 86. They dispose it off as a revision, my lord. I get it only on traces, my lord. On the website, I get it that it has been rejected as a revision at page 80.
Yes, what do you say?
And last order, your lordship, kindly see the last order also of the honorable.
That is there, that they considered this fact.
You have to explain also. You have to state the reason.
Yes, when their application is, my lord, it is to be treated as worst contract. That is their document, Lordship, kindly see, that is their application.
Page?
Page 80 and 81, his application.
Page 80.
It is his application, the form 13. Page 81, Lordship, kindly see, he has himself noted. Yes. And that is covered under 194C.
That is
And
under
my lord, that is
194C, my lord.
the subsequent.
That is the heading of 194C, my lord. That is the heading of 194C.
But thereafter, the ground for
Okay.
further
Order
addition.
Order reserved.
Well, it's that
You can
judgment
give me
and
short note.
so, well, it's some time maybe even
Sometime.
2 days.
Tomorrow.
2 days.
Okay, all of you fine. So for giving written submission, I am fixing it for day after tomorrow. For that purpose only. Okay. Next.
Item number 20.
Your lordship, for item number 20, we need 2 weeks time to file counter.
20. So you are for the income tax.
Income department.
for the petition.
2 weeks time to file the counter. To the income tax department. 2 weeks time to file the counter. You don't have any objection?
No, I don't.
List the matter on 9th October.
There's an interim order in my favor that may be
Okay,
extended.
matter to continue.
Much of that.
Yes.
21.
21, I'm appearing for the respondent notes in this case. So I just,
State Council for Technical Education.
the tribunal has held that I'm
Sir,
covered.
what charitable purpose you do, sir? You are
No, no, no,
state.
it's not a charity, my lords. They say that whatever I am collecting from the students is susceptible to income tax, levy of income tax. The tribunal holds that I'm covered under Article 289, sub-article 2, my lords.
Yes.
So they say that you are not a state, not your instrumentality of the state. my lords.
No, no,
That is
tribunal-
that is the crux of the issue. my lords.
I slightly differ. How they are not state? They are state. It's not a charitable
No,
institution.
my lords, it isn't.
Definitely, it's not a charitable institution.
And all my,
So
all,
there's my instrumentality of state is a government institution. State Council for Technical Education, vocational training.
and that is why the tribunal has held that I'm covered under Article 289.
So what is your answer to this?
There is a question has been sent.
Sir, question, is it not friend?
No,
No, I'm straight away, I'm giving this.
it question is sent
Okay, like,
because it's a,
where is it, sir? The
it's not
question?
a page 6 will
Yes. Like the,
then facts from the case.
the,
Got the IT
just
correct,
one,
holding the
just one,
assets.
sir, just one.
State.
The appellant has filed present income tax appeal under section 260 of the Income Tax Act. With a prayer to executive points of law, etc. in paragraph 7 of paragraph 1. Which are as follows. Whether the item is correct in the first article. Is a facts and circumstances so straight away whether the covenant is correct in holding that the SSC is a state. When the SSC society is registered under Society Act and has separate legal existence different from the state. Then 2. Two will available. 3 whether the settled law as passed by the Supreme Court in Adityapura Industrial Area Development Authority versus where it is held that income of authority is not the income of the government. Where the authority is justified under the act.
The citation has not been given. my lords.
We will find out.
My lords. Or it may not be necessary. my lords.
There is small. The state. Last question. Then, list for final hearing on 9th, 10th, 11th.
Puja chutti par theek hai.
Puja chutti par hai. So
Maybe
31st October.
First November.
31st of okay, first,
Immediately.
1st November. First November.
First ki second chutti ta.
Oh, ठीक है. Second कर दो.
Obligement.
Partially.
Sorry,
this issue is partially correct. The other thing is also you have to take care. One is instrumentality of state.
Manoj.
The other is there is a society.
Manoj.
There is it has it is under Society Registration Act.
Manoj. But
so whether it is state.
But all my lords functionaries are from the state on deputation from the state.
That is fine. That
so
can
the
be.
entire
That is a clothing. That is a clothing, but inherently that's and
it may be
as a society. So we'll see that. We'll examine.
But this development authority, your lordship knows, my lord, collects money, my lord, for say supposing approval of a plan or for other ones, which many other activities of a development society, of a development like CDA or BDA, my lord. They are covered.
But it is not like CDA. BDA.
It's not like CDA.
It is an educational institution.
Manoj.
An educational institution can't be run without a society. You can't just set up.
Manoj. So
there must be some society.
There has to be a society under which this educational institution runs.
We will examine that. Next.
Obliged.
Next.
Item 23.
May I please, your lordship? My lord, in this case, the department has come up with the appeal, my lord, challenging the order passed by the law and tribunal. But the issue, there are three issues, my lord, and the lordship kindly runs to the grounds. Three grounds. A and a B has been decided against the department in another appeal, my lord, in item number 95 of 120. But B, lordship.
Three questions. The question has not been framed here.
No, my lord. It has come up for admission.
Question number A. Question number C.
Yes.
They have already been decided by the court net bench of the Lordship Court.
Okay. The present appeal. The income tax is paragraph 2. Just the income tax passed in order. Court certified deputy. ITA number. For the assessment of the added the petitioner has raised the following question of the substantial question of law. First, the first is not a question of substantial question.
B, then the
That's saying B.
Present appeal is, my lord.
A is not a substantial.
A, no.
Whether
A, that has been decided by the
law honorable justified dismiss is also not a substantial. Let's see.
C has been decided in another appeal by this honorable court. B, my ground is, my lord, in this appeal in
C.
B.
See, you read that. Is there any substantial question of law involved? Just like just some facts, you are putting a question mark. Ho gaya question. At the end of question mark, there is a substantial question only. You should reframe it, sir. Please, whenever you are framing a question, it should look like a question. It looks like some facts and at the end a question mark. This is not the way you have to frame question. Why are you writing every time in the facts and circumstances? Of course, it is under the facts and circumstances case. This line is not necessary. Straight away come to the question. What is the question involved? Yeah. So look up. Whether the ITAT is justified in dismissing the appeal of the revenue by holding that the expenditure as a revenue expenditure incurred for construction of road which is providing long-term benefit to the SSC company instead of treating it as capital expenditure? One question. Second, whether the item justified by deleting the addition made by the jurisdictional SSC officer, by disallowing the expenditure claimed by the SSC. It is decided, still I am putting the question.
My lord.
Will write it. And disallowing expenditure claimed by the SSC under section 81A of the Act and giving leave to the SSC relying on the decision held by held in Alembic Limited bearing SLP number 807, but that decided at that time.
No, that is pending.
Pending.
Still pending, my lord.
Held back in the
Before the honorable office.
pending only held back in the liquid.
No, no, heard by this honorable court and the honorable court following
Yeah,
that.
that is, if it is pending, then it is not, the question is not yet, it has not been decided
Well.
yet. Where is it pending?
Well.
Let's see. Then only one question.
Well.
But at that time, it was not pending, at that time, even the relief was granted.
By the earlier.
Only B, only one question. Only one question, this is the question, sir.
Yes, this one.
And on the other day, there was a Kendu leaf go down
Yes.
was constructed somewhere. And that there was a demand, I mean, what the agitation, argument was on whether it is capital expenditure or revenue expenditure. How Kendu leaf go down is a revenue expenditure? It is long term, you are
That is,
housing the products there inside. It is a capital expenditure. How can it be revenue expenditure? But there was a question there.
How will you have a building?
Building, that building is for housing the product there. So this is not a revenue expenditure. So this is the matter on 16 October.
obliged,
You give you a short note.
obliged.
I'll finish it for final hearing. 16 October final hearing. These cases will take hardly 5 minutes.
Yes,
From
yes.
both sides, 5 minutes, 10 minutes. खत्म. किसी
Lots
नहीं
of-
है इधर.
Yes.
खाली आपण गुड जजमेंट दे दे दैट्स सबुतरे जजमेंट बारी
Mine.
is good. Next,
Obliged.
only one question. That is the substantial question actually. The rest of the questions are not. You give me a sheet with all the names. You also.
Obliged.
Okay, next.
24.
24.
My lord, on 24, day before yesterday.
I
I
will
received
ask
the
our
count.
time, I know.
My
Your
lord,
senior is not there. Right?
the-
Okay, so not the time. 10th October.
10th October. Lord, I will file rejoinder also.
Okay,
I will
file
file
whatever you
rejoinder.
want to file.
Interim order to be continued. my lord.
Interim order to continue. Next.
25.
25.
Same of 21.
Not this Watco.
What go?
Time at 20.
State, it is state or
Yes, I have read this.
just like 21.
So you, the question has been framed? What is your question, sir? Watco is not a state. Watco is not a state.
What is not a state?
How?
Page
So
number
we
5.
are following that Adityapura industrial area
Yes.
case.
Yes.
Huh?
Yes.
Okay, question, where is the question? We have framed.
Page 5,
Page 5.
1 and 2.
5, 1 and 2.
Same of 21.
ठीक है. The land control commission has framed the following question of law. One, whether the whether the attempt is correct in holding that the SSC is a state when the SSC company has a separate legal existence different from the state. Sir, these are state and
State.
instrumentality of state. These are instrumentality of state.
Yes.
Article 12.
It is a corporation. Let's just.
Sir, corporation is instrumentality of the state.
Yes.
Article 12. Article 12. Only state name. State and instrumentality of state all comes under that.
Okay.
Then next second here, whether the that is correct in holding that SSC is a state as per the federal law decided in Adityapura Adityapur Industrial Area Development Authority versus Union of India. 2 questions. Hello, only 2 questions. Okay, list the matter for same day.
Second November.
Same day.
Second one.
Nani, better now.
21 that.
16th October.
16 that will lagu. It is state. Sorry, you
No, that is final hearing of second.
Koda.
21 number.
Nani, ebe jo matter parjai ka question that is state sila na.
21 number.
16 re asu sila.
Sir, 21 number item apna roughly 2 take. Second number. You state.
Oh, acha, it is council. Acha, ठीक है. Okay. Yes. Second as.
Sir, apna second November karo.
Second as. Next.
26.
26.
These are batch of matters regarding that entry tax.
Yes.
But here actually, Your Lordship, last occasion directed, there are 2 other matters which have not been listed before Your Lordship.
Today is listed?
No, it has not been listed. 2 matters.
Can you give the number?
I've given the number.
So let it be together. Just let it come together then.
Yes, together it has to come.
Let the tag together. Present matter, list the matter.
Immediately after the Puja holidays.
Your Lordship,
second November. Huh?
It is small matter, so it can be disposed of 1 week after.
For the department is very small. For the party actually these are a lot big matters.
Anyway, second as.
Department is small, but party is
For
big.
Mr. Misread is small.
No, Your
Like
Lordship.
this misread is not small.
Your Lordship.
So actually, he's a very, very fair counsel.
Next.
Your Lordship,
27.
item 27, I'm sorry to submit, Your Lordship. Your Lordship, on the last occasion also I have sought time for filing of counter. Your Lordship, as a last chance. Hey, wait, I know in this case state will lose, but
1 week time to file the counter.
Your Lordship.
List the matter on 29.
Your Lordship, as Your Lordship, please.
October रख दो.
रोकना.
October रखिए. Oh, पहले रखिए. 12, 12. 12 October. 11, 12. 11 October.
Get full.
11 October, sir.
12.
12. Okay, 12. Next.
Get full.
28.
28.
May I please. No, here in this matter today, government has supplied the copy of the counter. But I request some.
File the regender.
Yes, just now there.
Regender is darka.
Yes, because there is here. I have challenged the government's fixation of duty after 5 years. We are the licensee for.
File it. We are fixing a little short date. We are giving you 26.
No.
Okay, 26. Kichi nahi hai tere. Kichi nahi hai.
I'll not be there. After third.
After third. Where will we going?
Bangalore. Son is there.
Okay, 4th. Okay.
Lord.
4th.
Okay.
Next. Next.
Interim order to continue.
Interim order to continue. 29.
29 Lord.
Item 29.
Interim order उगड़ा अच्छी बोली भी लंबा time दोगी. सेतिपे I am always focusing on short time. Interim order तापरे लंबा.
I require it to be decided early. Just.
Unnecessary.
Oh yes.
I will pardon to mention my note. Item number 18.
18. जोड़ा अपना आरोप करते लिख सकते हाँ हाँ दिया कब देवे मंडे ठीक है अपन नॉदेला माने पके नोट कर दे अपन नॉदेला में फोन करे माने पके okay next
Item 29.
29 also I am appearing here opposite party number 5 and some voluminous documents are there.
You want to read
it. Some
and you enjoy the stay.
No stay is there. Here no stay. My friend is appearing.
Subject to when do you want?
After vacation.
Remaining period of financial year 22-23. That means it is already over.
Over. But they are challenging.
I have challenged the shifting. I have challenged the shifting.
Shifting is over.
The shift.
Shifting, but thing is
Shifting
that
is also over.
No, my lord, I have challenged.
No, the period is over, remaining period of
My lord, that
2023.
period is order dated.
Thereafter renewal is made.
Huh.
My lord, may see, my lord, may see order dated 9/5.
Has been made, then you have to apply.
Yes.
9/5/2023. Order dated 9/5.
You have applied afresh.
No, no,
No,
some
madam.
order has been passed by this one court that it may not be infructuous.
Infructuous.
It is to be decided.
Alright.
So that's why,
Okay, ठीक है.
but
We'll decide.
under the facts and circumstances, it will be decided. When that period is over and subsequent year
Okay, next.
renewal has been made.
My lord is fixing.
And that
it
has
to-
not been challenged also.
Fixing it to third, ଆପଣଙ୍କର ବନ୍ଧୁ ତ ନାହାନ୍ତି ଆଉ କଣ କରିବେ? He'll come and after having Bangalore Hawa for some time and come back.
Holidays are there.
That's right. Bangalore,
Wonderful.
Mysore, ଅଛି ନା?
Yes.
Mysore puja. Okay, next.
Not this, in this matter,
Here
here I'm challenging.
This is also over, na?
No, my lord.
This matter is not over.
No.
That period
This is rejection order.
Hmm.
This is rejection order, I have challenged, my lord.
For
But
the
they have
remaining
not-
period, sir. For
But
the
it
remaining
is
period.
it is a
of
grant of
20
license.
that is
Grant
one.
of license has been
That is
rejected.
over, sir.
No, here will not be over.
For the if
That period, that rejection if goes, not I will go back to that date. Because this order has been passed, not without assigning any reason. Lots you will find
Which order?
simply,
Where is the
annexure
order?
1 page 12.
Page 12.
It's here a grant of on license. I have applied for grant of on license. And my lord, Lordship says.
Without assigning any reason.
Yes, my lord.
So let's go.
Lordship, I
There-
have glanced page 12, annexure 1.
Page 12.
Yes. Inviting reference to your letter so and so, I am direct to say that proposal regarding grant of new apples on license in favor so and so, in place of so and so, for the remaining period 22-23 is rejected.
But the Commissioner of Excise has given a detailed order probably.
Not, that is not order.
Annexure 9.
Not that collector and commissioner's recommendation,
Hmm.
I challenge before the revisional authority, before the government.
Hmm.
Not government what has done, before hearing that government revision, this input order has been passed. And thereafter, they decided that revision is not maintainable. That is annexure 2.
So, what do you say?
Again, to be decided
We have filed our
on the merits of the matter.
For the remaining period of 22-23, probably the period is already over, sir.
But it may be over, but it can be continuing Lord, next year.
How can we? Unless you apply for praise,
You have to apply for it, sir.
you have to apply praise then.
No problem for submitting application.
Huh.
But this rejection order, Lord, when it has been passed? 10-10-22? This order
Yes.
has been passed on
Yes.
10-10.
But
But for
remaining,
the remaining period.
for the remaining period.
But
Nay, whether a praise order has been issued,
no press order, not required. Not, this is on my application. Here
No,
it is not
me,
lottery or any auction or anything. Here on my application, that ID number is there. On my application, it has been processed. So this rejection order, if it goes, then I will go back to that date.
even if the rejection order says that as per the proposed site violates the provision contained under rules 26.
Yes. If
Due to existence of your petrol pump.
no,
petrol
petrol, that
belongs
can
to
be
you.
relaxed. 26
That
proviso.
has not been relaxed, sir.
No, that they have not relaxed.
And some
Inspector,
objection by the Sarpanch also.
no, Sarpanch has objected
And
because
once
in his father's name, within
And
600 meters, his shop is there.
and
That's
one-
why he objected.
And one Sisu Mandir
In
is
his
there also.
father's name, Sarpanch's father's name, that I have stated.
So, Mr. Councillor, one
Yes.
Sisu Mandir is near to that.
That is also not a recognized institution. That has not
You
been
are there in
considered.
the
Let,
earlier.
what I'm supposing, proposing, I'll submit an application with all documents. Let them consider by government again after. No, that they have stated there is a school.
No,
That
whether
is
the
not a
period-
recognized school.
Would the
School
period,
is recognized on.
No, that school has been
what
granted,
kind of school? is it?
recognition has been granted to some other place and he has opened in illegally in another place. So how it will be recognized?
So except you, everybody.
No, that I have stated in my
Except
petition.
your thing, everything is unauthorized.
No, I'm not
School is
saying.
unauthorized.
No,
Petrol pump is unauthorized.
no, petrol pump is mine. That I want relaxation. That I want relaxation.
That's why I'm saying.
That I want relaxation. That proviso is there. Government has relaxed number of cases.
Saraswati Sisu Mandir EP school is at 400 meters.
That I'm saying.
Site
Lord, it
temple is
he
510
is open
meters.
at Naima, but he has opened at body Naima. The school has
But
opened
yeah,
at Bada
ଆପଣ
Niga.
ଦୂରକୁ ଗଲେ
It is
ଅସୁବିଧା
a
କଣ?
10 kilometers south.
ସେ କାହିଁ ସ୍କୁଲକୁ ଯିବ ଆପଣ ଦୂରକୁ ପଳେଇଲେ ହବନି?
There are more restaurant, ଏତେ ବଡ restaurant photo ଦେଖୁନାହାନ୍ତି ଦେଖି
ରେଷ୍ଟୁରାଣ୍ଟ
And one another on shop is there also.
ମୋର restaurant ଅଛି ଲେଖୁଛନ୍ତି restaurant ନାହିଁ ଆଜ୍ଞା ground ଦେଇଛନ୍ତି restaurant ବି ନାହିଁ
Restaurant was not functioning on the date of inspection.
inspection ସବୁ ଅଛି ମୁଁ
Everything
ଆମ
is
ପଞ୍ଚାୟତରେ ଏକ
GST filing
ନୂତନ ଠିପି ଖୋଲା
GST
ବିଦେଶୀ ମଦ ଦୋକାନ ନ ଖୋଲିବା ସମ୍ବନ୍ଧରେ ଇନଭିଟେସନ ହେଇଯାଏ ସାର୍
Sir,
subsequent period ପାଇଁ
ନାଇଁ
ନା এইটা তো অন শপটা
on shop
অন শপটা নট এ অফ শপ
Oh, sorry.
it is on shop
এই হোটেল
yes hotel restaurant
okay.
Madam, there are many restaurants, but license cannot be granted to all restaurants. What he is saying that there is a big restaurant, there are many big restaurants. You can operate the restaurant, but so far as issuance of license is concerned, there are certain criteria. And what the revisional authority in the impugned order has held, that there are some restrictions for which he is not entitled to get.
no revisional order says that it is not maintainable. Your revision is not maintainable because it is a recommendation of the collector and commissioner. Against that order, revision is not maintainable. When they have assigned reasons, so I have filed revision. They have stated that your restaurant is not there and there is objection of sarpanch. That I clarified.
What are the other
But that was not considered.
What are the other objections?
That part, my lord, otherwise no objection.
Where is the
Except
provision?
sarpanch and
Where is the provision of revision in Excise Act? Whether it is
Section 6. That is the government is the revisional authority, secretary.
because my lord, government is the authority to decide with regard to grant of license. So I filed before the authority. No, that
Rules or act?
section 6. Control, appeal or revision.
The state government may revise any order passed by a collector or the excise commissioner, but either on its own motion or in the application of any person.
I filed revision. I filed stating that there is the restaurant is functioning. The objection filed by the sarpanch because another 600 meter from my restaurant to another 600 meter, this on shop is functioning, and that is in the name of his father. How you will accept that objection of sarpanch?
That's okay. He's a competitor.
Yes,
Sarpanch cannot.
He is a competitor. He is saying his father has a shop. So indirectly competitor.
And how
maybe is a clothing.
Yes,
His
in my
clothing is
application
only
specifically
sarpanch.
state and his name has been stated at
তার father
ବାପାର ଥିଲା ତେଣୁ rivalry ଅଛି ବୋଲି
What about the Saraswati Sishu Mandir? Then
no, Sishu Mandir will not be applicable because that restriction is there. But he has not opened the school has to open at Noiga. But he has opened Bada Niga, where I have proposed my onset is at Bada Niga.
so the school is functioning, I think.
In the counter affidavit, resign affidavit.
So you are saying that
documents
the school is going to be shifted to that new place.
Because one recognition has been granted to
No,
some
I'm
place
asking you.
is to open there.
No, but
In a rented house they have to open.
but still
That's
school
it.
is going on.
Is
na?
continuing, na?
School is there. And that part
obviously-
also can be relaxed. 26 days.
How
Yes,
can it be
so-
relaxed?
It is not
Because you
No, I just-
Relaxation is the discretionary power. Relaxation is the
Yes, that-
discretionary power.
And
No, I will file application before the government. Let it be considered afresh. Taking into consideration the facts of what there.
My lord,
I filed that.
let me first submit one thing, your lordship. As per the new excise policy, no license can be issued as of now because we have stopped issuing license for rural areas and it is coming to rural
Okay,
areas.
it's coming to rural area.
So only in urban area having lodging minimum 10 rooms, then only application can be considered.
So few days back also there was a case of rural and urban.
Yes, the number of cases has been filed. Government has
there,
government
but
has
so-
rejected in a one line.
As a matter
If
of
it-
principle, as a
If,
matter of
no, no,
policy
if your
decision-
lordship is interested to remand it back, asking him to, then your lordship may also note that according to the existing policy.
Obviously,
Obviously.
obviously, that is there.
23-24 policy. If permitted.
Where is your recommendation?
No, I have not filed in this. I'll file.
Not filed.
I'll file
Oh,
press
you-
representation with all documents which have been filed here in the petition.
Recommendation before,
Government, excise department.
excise secretary.
Secretary excise.
Secretary, OP number 1.
Not before the commissioner.
No,
No, no,
only he is the authority. He is the final authority under rule section 41.
Petitioner. Approach the
OP number 1.
OP number 1. Within 2 weeks from today. Within 2 weeks from today. And the OP number 1 shall decide the recommendation.
In accordance
In
with
accordance with the
existing
existing
excise policy
policy.
23-24.
Yes, existing. excise
Existing
policy.
only,
Yes,
not
sir,
required
that's
23.
Existing policy.
Ke clarity ପାଇଁ ମୁଁ କହୁଥିଲି ନା
Existing means
within the next 1 month.
yes dispose
My lord, petitioner had purchased a tipper in 2019.
Tipper?
Yes.
Tipper ke tipper?
Tipper.
Tipper. Okay.
In 2021, it was registered.
तो आपण आपका पार्टी पाहिले नहीं सीधा रिजर्व बैंक ऑफ इंडिया खोर्धा के कबे पळे आला तो बॉम्बे रे आमे समझते जानिछु अब रिजर्व बैंक ऑफ इंडिया खोर्धा को नहीं आइलेनी खोर्धा रे भी तो नहीं तो रिजर्व बैंक ऑफ इंडिया
ଗୋଟେ ତାର ବ୍ରାଞ୍ଚ ଅଛି ନା
खोर्धा रे
ଅଛି ନା କଣ
खोर्धा रे ब्रांच
ଭୁବନେଶ୍ୱର
आया भुवनेश्वर कहबे खोर्धा लिखि
ଭୁବନେଶ୍ୱର ଡିଷ୍ଟ୍ରିକ୍ଟ ଖୋର୍ଦ୍ଧା
एमती गला केंद्र भुवनेश्वर डिस्ट्रिक्ट खोर्धा लिखि और खोर्धा लिखि दे आरबीआई खोर्धा इवन आरबीआई खोर्धा भी रॉन्ग हां रीजनल ऑफिस आरबीआई लिखि ना
he had purchased a tipper in 2019 my lord.
आपण भितरे भी आरबीआई सबडे लिखि आपण पार्टी बनवे गोटे सेशन टे नियंतु
नहीं सी कौन होचे के
मिस्टर कर हैव ए सेशन ऑन पार्टी पार्टी किंदी बनेबे गोटे सेशन टे नियंतु कोन गोटे सेमिनार करंती मिस्टर त्रिपाठी भी आपण भी करंतु हां कोन पार्टी पिलान बने जाउ नांती आपण सिखेबे नी मैं 2023
हां
ओके
पैरा 2 लास्ट
रेगुलराइज कर दियंतु डिफॉल्ट
प्रॉब्लम कोन होची
23 माने मैं जून जुलाई 3-4 मास
नहीं नहीं प्रॉब्लम कोन होची देखो vehicle loan टा 8 लाख रे नहीं चले 7,49,000 is outstanding dues. Overdue कहले 30,181. तापर next पे
EMI केते
EMI टा ताकर करचंती 6,63 टका प्रति मास.
गोटे काम करंतु
हां
रेगुलराइज
फिर प्रॉब्लम कोन देखो नेक्स्ट पेज का देखो 11 एटी गोटे last page your lords may see para 4 for the reasons stated above we are hereby giving you
sir one thing your see your loan turn NPA when did it turn
NPA in May 2023 May 2023 May 2023
2023 NPA ला ता पूर्व 3 मास रे आपण देना थी हां ता पूर्व 3 मतलब मार्च रे आपण देना थी मार्च अप्रैल मई 3 मास रे आपण देना थी
नहीं मेरे दिया ही
रुहंतु मैं मु पचार छी एनपीए जदी हेबो एनपीए केबे हुए तीनटा जदी आपण 3 मास बिना न देले एनपीए होची गुटे क्वार्टर पूरा तो जब न देले एनपीए होची तो आपण देई नाथि बोल तो एनपीए हला मेरे
जे केते हम दवा पड़ो सेटा डिटेल दउ नाथि एठी कहउचंदी 7,49,000 आउटस्टैंडिंग ड्यूज
क्या समझा
ओवर ड्यूज हैला 30,101
अरे आपनकर तीनटा इंस्टॉलमेंट देलेनी बोली एनपीए हला बैंक को जाई थांते तीनटा इंस्टॉलमेंट प्लस इंटरेस्ट प्लस पेनल्टी वाटर ब्ला 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 देई थांते रेगुलराइज कर दे थांते किछि कलेनी बसी पड़ले एबे आसिले हठात सितंबर मास रे निंदटा तमर आपन निद भांगिला
हियर दिस petitioner
केते टोटल अछि के
my lord he is having a 7 loan accounts. If you one account is NPA, other accounts is automatically treated as NPA because the NPA is always a borrower wise, not a account wise.
Right.
So this being the position, my lord, the party had filed a consumer forum case before the district consumer
forum कोन करबे एतरे पैसा देबे नि consumer forum जिबे
राउरकेला then ना फाइल करछन
पार्टी करथिबो that is not within my knowledge
sir
that is not
party कोन you are representing your party
no
I don't know who are the I know the party only you may be representing anybody
consumer forum case number
what's his vehicle loan what is the outstanding
sir why have you approached the consumer forum tell me
then matter come to the state forum
total amount केते ड्यू अछि कोन तुम
total amount
केते ड्यू अछि एई पर्टिकुलर केस रे
ए
पर्टिकुलर टिपर वाला
टिपर टारे
पेज 10 you lords में काइंड
टोटल केते अमाउंट कोन आछि
total outstanding dues अछि 7,49,000
let them solve the read
दे दियंतु
copy
टोटल अमाउंट दे दियंतु खत्म कर सेटा यार 7 लाख 7टा अकाउंट अछि से तो गरीब
सब जगह देले जाय कि
गरीब लोक तो 7टा अकाउंट मेंटेन कर
that is the policy of the reserve bank my lord
कौन सी गरीब लोकर 7टा अकाउंट मो पसर जदी फ्रॉड हेतिबो तो हेथे पारे नहले जनरली कौन सी गरीब लोकर 7टा अकाउंट नहीं आपण गोटे काम करत आपण डेफिनेटली पैसा वाला कॉपी ऑफ द रीड कॉपी ऑफ द रिपिटिशन on Mr. Tuna Saw who is appearing
I am filing the power also in the course of the day
yeah the Bank of India
OPG
and he further submits that the present petitioners both are party na? The present petitioners are ସବୁ ଗାଡି ଲୋନ ନୁହେଁ sir. Commercial vehicle ଗୋଟେ ଦୁଇଟା ତିନିଟା ଚାରିଟା ପାଞ୍ଚଟା commercial vehicle. बाकी जो GECL कौन है?
मिलर गवर्नमेंट इमरजेंसी लेन जो कोविड लोन जासिला कोविड लोन टा सर्वाइवल पे से उडे लोन दिया गला
सर्वाइवल
हां
पर्सनल लोन भी नेले GECL नेले छन गाड़ी ता तीन चारटा गाड़ी नहीं छे चारटा गाड़ी तो लैंड काउंसिल पिटिशन सबमिट दैट in all the vehicle loans he has taken from the bank the overdue the amount overdue is very huge. Hence, he wants to take instruction from the bank.
I'll solve in course.
Yes. Next, don't expect anything good from me. Upon Sabu, upon client who come to Sabu NPA Koribo, a bank on Chacha, the bank Sabu Yekoribo. So definitely settle this. Bolo तुम्हारा चाचा नहीं है बैंक किसी का चाचा नहीं है तो देश का list the matter on 25th September छोटा दे दो चला next
25th May.
Item 2. Miss Cuttack Development Authority before minors against order of the consumer forum minors. I'm conscious of the position that minors have in the meanwhile have dealt with few of the consumer cases.
What is the issue?
Issue is very simple, minors. Somebody applied for a plot like others. He was never selected to get a plot. Let us consider for the moment that he has been selected and provisional allotment letter has been issued. Obviously,
you're saying never selected.
No, he was never selected. So only he applied, then the application form was given a registration number. And on the basis of that, the learned consumer forum, our consistent case, there is not mental, he is not a consumer at all. Because there is no allotment, he has not been selected for some reason or other, whatever reason may be. Then the consumer forum said that they are a consumer and that should be entertained. Completely want of jurisdiction.
So आपन
It's not totally consumer.
What is your grievance, sir?
Yes.
My let's issue notice. Issue notice. Issue notice टा करो तापर कोडी पठेबा से आसु issue notice to open number 1 to 3 by registered post to ready list the matter on 27th
27th.
Yeah,
it is execution proceeding ta step.
Execution proceeding be stayed in the meantime. There should be stay of the operation of the impugn order under the next 6 and other proceedings in execution case number 30 of the and also CC case number interim order against
No. We have the forum, the district forum said we raised objection.
I don't know what happened to this forum nowadays. District forum, state forum,
let us not pass any comment on that because they are all part of the judicial process.
I mean, even now the group of people who have joined the bandwagon is the PLA.
With due humility, fighting out matters to occupy the chair. Fighting out matters to occupy the chair.
Utility service that is the only thing. Wrongly, they are passing so
many unless minors interface in 1 and 2 cases framing guideline, the situation will not develop minors with due humility. Of course, I should not have said minors.
I know this is right. This is actually they are interfering unnecessarily wherever they are not supposed to.
Yes, ma'am. That exactly.
Next,
I will take notice within 3 days, ma'am.
3 days. Yes,
please.
Item number 3.
Appointment was made by following due process of law for an Anganwadi worker.
Due process of law?
My lords. While I was
due process, where is it? In which constitution the due process is very popular? Word in the due process, where is it?
It's Article 14. Although it's not impliedly.
Due process, there's a constitution. Due process is very, very significant. Recently,
there are 2 aspects. I shortly recall. due procedure established
Due
by law.
process of law.
Due,
Which constitution has emphasized much on this word, due process.
so I'll get, I'll do that.
But
But there are two aspects. That's
That's
the two aspects only what I recall.
Go
Malad,
and go and today read
due
American Constitution.
procedure established by law and
Go
due
and
process of
read
law.
American Constitution.
Whereas we don't, we recognize at least one of them, what is process of law, and we don't recognize. the
Did
process
I
of law.
ask, recognize or not?
That's
You
what
said
I
you read
recall.
that book.
I'll read it.
Yes.
Let's, while I was continuing in the service, the CDPO has issued a letter of advertisement, Manoj, to be specific, stating that there are vacant posts and their eligible candidates may apply to the said post. Manoj, this particular order, I had been before your lordships in another.
No, I'm
matter.
asking what is the, you are continuing there, then what happened?
Well, sir, the CDPO
You
issued.
are continuing as Anganwadi helper.
Helper.
Ah.
Well, while I was continuing, the CDPO issued an advertisement.
Okay.
Now, in that advertisement, it was stated that the vacant posts will be filled up. The similar issue, Malaj, was raised by me by another writ petition, and it is the same order, Malaj.
You have that order?
I am just placing that. I'm sorry, Malaj, this order is not uploaded. So since I was appearing for the petitioner, so I got a copy of the true copy of the certificate. It is of the same Gram Panchayat. This petitioner which your lordships are seeing, he was in Bhubanpalli. So she was in Bhubanpalli. That was the name of the Anganwadi center was Mandirpoda.
Where from you got this?
It's because I am appearing for the petitioner in that particular case.
But you are not supposed to.
I'm appearing for the petitioner.
Uploaded, you are saying it is not.
It is not uploaded. So I have applied for certified copy. I was appearing for the petitioner in that case also. So that's the reason why I said Malaj. It is not
some sneaking activities.
No, Malaj. Not at all. Not at all.
Okay. Next.
Okay. Well, just IE, Malaj, I also have an IE. One more thing. Your lordships were saying about the constitution. I will just note down the book.
I have to tell you the name of the book also.
I'll American Constitution. I'll get a good.
Give your email address and the book. Email ID. I have a soft copy.
I'll
give your email address to.
I'll send.
Anybody wants that book, I can send.
I'll
soft copy I have. I have a maximum. I have soft copy. I don't have hard copy. Very few hard copies. So if you want, I can say.
I'll
next.
Land of the present 4 petition was acquired for expansion of NH 49 mallet. Out of 0.89 decimal, 0.34 decimal are applied, and by the annexure 1 petitioner in the LA case, petitioner filed that to acquire the entire building, because the front side of the approach road of the building was acquired by the land acquisition officer. Therefore, the entire building is not unusable, my lord. Therefore,
LCR Kasi.
Because the entire 2 storage building, and since 2014, it was in unusable condition, my lord. Vacant, it was rented to bank, my lord. Therefore, my lord.
Yes, what is the issue? Can you repeat?
My lord, the land was acquired for expansion, my lord. Out of, my lord, 0.89
expansion of
NH 49.
NH.
And out of
pura pura land was acquired for expansion of NH so and so. Pura koibe na adha expansion koidle rahigale. Fer mu jodi. Pura koibe na.
Out of
pura kondu sentence pura adha koibe.
Out of 0.89 decimal, they acquired 0.035 decimal matter. The front side of the area matter of the building matter, including staircase.
Front side of the building,
including the staircase matter. Therefore, petitioner filed his objection in LA case to acquire the entire building matter. But they did not consider. Therefore, petitioner filed the arbitration case before the collector.
What is the collector? What is the order?
Annexure. Page matter, page 13, annexure 2.
Collector
reassess and for direct for re-examine and re-access for further matter. Page 15. In view of the fact examined, the miscase is allowed. The opposite party no special land.
Arbitration is dismissed.
My lord.
You have, yes. Is dismissed stating what?
And no, they order page 15. In view of the fact examined, the miscase is allowed. The opposite party special land officer competent authority NS6 can direct to calculate the compensation afresh in case of taking into consideration the value of the acquired land structure passed in the original award, my lord. Thereafter, they enhance, my lord. Only they include the portion the staircase, my lord, but remain the other part of the building, my lord.
So actually you have a total. What is the area? Total area,
my lord.
89 decimal.
My lord.
Out of that, how much they acquired?
0.35 decimal, my lord.
Rest is not acquired.
My lord.
क्या भाई आधा लेते हो आधा छोड़ देते नोटिस जो एक लगा
नहीं फर्स्ट टाइम
ना ना लास्ट टाइम लाइक ना अच्छा एलसीआर फिल्म ओके इशू नोटिस टू द ऑपोजिट पार्टी returnable on 12th October. How the person will leave the land? Half of the land is taken away, half of the land is staircase and
this is the photograph.
Go what possible.
There is no.
I can imagine that. No need to show photographs. That's very difficult situation. You should acquire the whole patch. This is not a big patch. I can understand. Had it been a 10,000, 15,000 square feet area, that's so different. A small patch,
Yes.
half you are taking, half you are
Including staircase, they have already acquired.
You take instruction. Issue notice. Next.
Item number 5.
Here I am challenging the order of disengagement
of
Shiksha Sahib. My lord, for better appreciation, I want to draw my lord's attention because earlier he has come to this honorable court.
Earlier से कितने तरह अच्छी sir? कितने तरह अच्छी? एक, दो, तीन, चार.
Representation dispose reject हैला. तापर पुनी again आसिला. Again आसी साला पुनी say order. But last order, that is the final order.
ये खाली High Court आसी जाए ये
कौन गरीब लोग का यहाँ
2008 गरीब लोग का 2008 रू चल जी.
And this will be end here before your lordship.
I don't know it will end here or not. I don't know, but
my lord, I hope.
What is the case? Actually,
I hope this is the last case, and he will get benefit.
No, in the last, no, unless tara energy or energy will be lost totally after coming to this court for so much time.
In an identical matter, he had also come twice or four
times. That's why I always. That's the only reason why I hate this representation business. You finish it this way, that way.
That's right.
Which are the
primary school teacher. She was harassed by some people. She came 2-3 writ applications were filed. Your lordship said same thing. Your lordship directed, Mr. Tripathi, if you are satisfied, you go to DO Puri, district education officer, and submit a detailed representation. You argue yourself. Thereafter, I was allowed. She got appointed. That was the final order.
Very rare cases that is happening. That is happening in rare cases.
Sir, rare cases. But
so now come to this case. What is this case?
This is the case. He was appointed during 2007. Then headmistress of the school did not allow him to continue
from the beginning.
This is the
from the beginning.
My lord, 2007.
Never worked.
No.
Why?
काम करी 5-6 मास काम करी तापर ताको allow.
Why? What is the reason?
ये something he read against the headmistress जे आपण एटा करजंती सेटा करजंती ता भूलटा कहला मात्र के ग्रज रहिला. That has been mentioned.
Always boss is always right, sir.
However,
that is just saying na boss is always right. You can't raise a voice against boss. Boss against a particular कौन हो?
But to
boss बोलते ले भी right.
हाँ sir. Sir, to impress my lord, I want to press page 31 of this court order. Page 31, paragraph 4.
एक कोर्ट ऑर्डर के साड़ा दूँ आप सीधा स्ट्रेट कम टू द पॉइंट एबे कौन करिएगा एक कोर्ट रे चार थरा ऐसे चारटा ऑर्डर पास तो
हां तास होता एक ऑर्डर कले जे विजिलेंस रिपोर्ट को बेस करके ओपी नंबर 1 डायरेक्टर को सेक्रेटरी एजुकेशन को डायरेक्शन देले
विजिलेंस रिपोर्ट कोन भाई
आज्ञा
विजिलेंस रिपोर्ट कोन
विजिलेंस को मु लिखि कि देली मु कहली कोन आज्ञा मु भूल करछि मते काहे कि हेडमिस्ट्रेस ई कोनाती यू गो एंड इंक्वायर इनटू द मैटर विजिलेंस भी गले एनक्वायरी कले
ଆପଣ ଏତେ କାଣ୍ଡ କରିବେ ଆପଣଙ୍କୁ ରଖିବି
विजिलेंस रिपोर्ट
ଭିଜିଲାନ୍ସ କୁ ପଳେଇବେ ସିଏମ ଅଫିସ କୁ ପଳେଇବେ ଗଭର୍ଣ୍ଣର ପାଖକୁ ପଳେଇବେ ଆଉ ତ ଆପଣ ରଖିବି ସେମାନେ
देन माय लॉर्ड
शुड बी डिसिप्लिन सोल्जर भलिया काम कले सिना ଆପଣ ହେଡମାଷ୍ଟର ଆଜ୍ଞା ଲାଗିଲେ
from this honorable court I want to read paragraph 5, page 31. It is submitted by so and so learned counsel for the petitioner that in his representation the petitioner has specifically referred to the report submitted by the DSP Vigilance Khordha Square on 31st May 2007.
आज anyway खाना दो से अपने पसंद what is the
glance to page 36 my lord
36
long unauthorized absence my lord
आपण ताको जॉइन करे देबेनी लॉन्ग अटेंडेंस कोन आपण ताको काम करले देले त से रहइबो
नहीं काम करे
से टीचर अछि सेडी से टीचर सेडी अछि ना से टीचर भी पळेलानी
हेडमिस्ट्रेस
से गलेनी से थिला बेले भी मु लेखिली मते आपण भल पाना दे
2008 केस थिबा बेले लागोनी 2008 रो केस एटा
अरे 8 रो केस तो 8 रो केस आपण जने लोक को काम करे देबेनी सी बारंबार कोर्ट को आसीबो ता 2008 को 2010 में हो 2006 भी हो so
then my lord
what is your I mean
page 36 my lord
36 yes 36
paragraph 8 my lord whereas the main contents of the petition is that he had submitted the annual agreement paper during 2008 for renewal of his engagement. In spite of that, the district selection committee had not renewed the engagement. The claim of the petitioner is not based on the facts. The engagement of Sikha Sahak is purely on contract basis. The engagement needs renewal after completion of 1 year, basing on the positive performance certificate of the village education committee. Here, the village education committee has not obtained that certificate from the village education committee.
How I give it? Because the headmistress is against me.
Sir, but your post was not regular. It was a contractual job, sir. You have to get it renewed every year.
Yes. It will be renewed every year. Within 6 months, they did not allow me to join. How will continue for 1 year? My lord, that is the cock of the case.
But how do I know that you are?
My lord, for that reason, inquiry was conducted. Your lord,
what is the inquiry report? What is the inquiry report?
Page 16. Page 16, 2 lines I will read. The report of the inquiry. Page 16, last 2 lines. Under the above circumstances, the termination of the petitioner is quite illegal.
What did they say? This is
the report submitted by the DSP.
Okay.
Vigilance.
So what is
Under the above circumstances, the termination of the petitioner is quite illegal, for which a report may be sent to the concerned department for taking action as deemed.
So how this the
vigilance
is deciding termination is illegal or illegal?
Depending बुझिबेनी लोकमोटू प्रकृतरे लोकटा भूल करछि कि ठीक करछि कोन करछि
तार स्टेटमेंट को आपण लागो
सेही थु तो हाई कोर्ट ऑर्डर कले जे विजिलेंस रिपोर्ट
विजिलेंस वाला तार विजिलेंस साइड देखिबो से टर्मिनेशन राइट की रॉन्ग से काई कहबो
नहीं देखिले जे आर किछि दोष नहीं देयर आफ्टर योर लॉर्डशिप
से केन जानला विजिलेंस वाला तो विजिलेंस एंगल को देखिबो ना से काई तार दोष थिला नथिला से केन
विजिलेंस सर देखि कि रिपोर्ट दिला परे this honorable court directed basing on the report you consider the case.
I am also doing the same thing. Basing on the vigilance report, you consider the case.
Yes.
Consider करिवेनी.
Vigilance जदि कहला जे मोर किछि दोष नै I am निर्दोषी. Then
आपनकर first thing हला कि आपनकर एटा होजी contractual job. You don't have vested right. So they have you apply somewhere and get job. This is the only thing. Can't be clock can't be reversed now at this stage. रेगुलर जब हेतांता आई कुड हैव थॉट ऑफ कॉन्ट्रैक्चुअल जब रे सबुद्र बड़ा जिंस हला आपनका इनडिसिप्लिन दे डोंट टॉलरेट नंबर 1 नंबर 2 you are supposed to renew every year that has not been done so right सेटा से भीतर को मुझे बात नहीं rightly or wrongly the renewal has not taken place number 2 number 3 whenever you are in an organization you have to have some discipline you can't write against everybody then they will
not everybody my lord
hala se lok bhi ja apnar boss against
the headmistress Mamtaj Begum she did not allow me
se allow kon pai kar काम तो कले पुनी 6-7 मास किंतु
नहीं काम कले नहीं से 6-7
starting allow न करी ना काम आपण काम कले 6-7 मास पुनी ना पई
sir it so happens in some places your lordship has also
but here court what the court will do sir you just tell me what the court should do
My lord, if the order is wrong, then
How do I know your order right is wrong?
no, your lordship may kindly see.
This vigilance order is not, this is vigilance is nobody to certify that this is rightly or wrongly terminated.
Then your lordship may kindly.
Vigilance is no business.
Nahi sir, High Court कहले जे तुमे vigilance report को देखी कि काम
एटा कहले High Court कौन कहले मुझे बात नहीं मोर कहवा कथा
Then
है
last
vigilance is nobody to certify that the termination was right or wrong. Because vigilance has to do its own work. Vigilance angle को से देखियो ये termination ठीक भूल धड़ा departmental ये
that will be decided by department. Vigilance has submitted the report. So High Court said, you basing on the report, you decide your case. Last page था साथी देखो तो page 39. What was the order passed by the competent authority? Page 39 last deal पढ़ी.
यार भाग्य टा बोलना हम कौन बोलेगा?
My lord, page 24. Page 39, paragraph 24. Order of the commissioner. Whereas the DSP Vigilance Khoda had submitted the inquiry report on the complaint of the petitioner to the SP Coordination Vigilance Directorate Cuttack for sending report to the concerned department for appropriate action, but no such report has been sent from the vigilance organization to this department. Hence, the report of the DSP Vigilance cannot be a conclusive report.
Your wife is also working.
My lord.
So for your wife there is no problem.
No,
She comfortably doing it.
No.
ये बड़ा कुहाड़ा उड़े ही थी वाउ.
नहीं किसी ना. I just simple man my lord.
I'm simple man.
Simple. Yes.
आरे गाली simple ना. गांव लोग वैसे खतरनाक. Simple ना बोलें. ये तो आगत थिले जमाना गलानी. सेमाने उधर गुटे election हले same election हले MP की गुटे अलगा लोग उधर जो MLA गुटे अलगा. सही जमाना गलानी आगो ना ले सही गुटे जगह वोट मार दो. सब लोग चला गए सर. गांव माने तो वैसे चला. जेतु छता जोता आसिलानी सेदिन बेसी चला गेलनी बेसी काम नै ना there is a saying in geography one कहावत है Mackinder Long in the 17th century he said that people in the plain area tend to be very complicated. People in the hilly area tend to be very simple because the hilly area people they spend much of their time in collecting food and all that. प्लेन एरिया धाना चाष कर देला गधा धान वाला गहम वाला खाई को ग्राउंड रे रखी तक मूवी द शेयर करियो
only ground. But I have submitted
contractual जाओ सर
but my lord I have implored the vigilance report before your lordship में direct for reconsideration my lord because vigilance report ताको पाके थिला से consider करना है. I want my lord is a poor man.
Sir Odisha 80% poor 80% of the people of Orissa are poor and 20% of the people of Orissa are very rich and they own the 80% of the property of the state. This is the situation. So poor ke nahi, some poor. Orissa adha logo poor. Adha 80%.
But this order is very illegal. Amaro commissioner को पाखे vigilance report अच्छी से कोजन
first of all commissioner vigilance report जीवो कौन भाई अपन का termination मतलब vigilance report कहीं जीवो से
because High Court has passed the order you go through the vigilance report for that reason my lord.
It's not a case for him.
Your last line but no such report has been sent from vigilance department.
छाड़ा तो vigilance से मुझे कहीं पड़ी since you have order reject next. Next.
My lord, order is there, my lord.
Order.
I pray your lordship may direct for reconsideration at least.
I'll do that.
I'll. Again, basing upon that report, the High Court order करिसेंती once में basing upon vigilance.
Sir, High Court तो चारी थर order करिसेंती. कौन टा? किसी तो है नहीं ना.
That final order.
5 number थर रा कौन टा हो? किसी है वाली.
Otherwise, my lord, you will be harassed like anything.
He has already 8 ru 23 तक कौन है जीता रहा? You are for the petitioner.
Lordship. And after the death of my mother, myself and my
give a copy, sir. Give a copy.
Lordship,
unless you give copy, how will you come prepared?
Lordship, I have solved the copy on the bank, Odisha Gramya Bank.
Bank ta dei ni council ke copy devo le sine abo.
Lordship, I do not know who is the London Council appearing for the
Mr.
bank.
Tunasa is a popular man in the High Court. What are you saying? You don't know. If you don't know Mr. Tunasa, you are not from this bar.
Lordship,
from
I know
bar.
very good practice, a bank practitioner since last.
Yes, he is here.
Yes, Lordship,
give a copy.
Lordship, I am serving a copy. Or
ଆପଣ
Lordship,
ସେଇଠୁ କରିବେ ହେଲେ ୟାଙ୍କୁ କପି କେମିତି ଦେବେ?
Lordship, my associate is there. They will serve the copy
Okay,
on
where
this.
is your associate? କାହିଁ ଦେଖା ଯାଉନାହାନ୍ତି ତ?
Lordship, I am telling they will serve
ହଁ।
during
ପୁଣି
course of the
କହନ୍ତୁ
day.
ସେ ଏବେ କପି ଦିଅନ୍ତୁ ହେଲା। List the matter on 25th ଆସୁ।
Lord, direction in the meanwhile, petitioner will submit, serve a copy of the read petition.
That's what his junior is giving you.
Lordship, I am serving. I know Mr. Shaw, I am serving.
Sir, copy सब कॉलेज ना से नेपे instruction ना। Next.
Lordship.
Item number 8.
8.
May I please, Lordship? Lordship, the present date application has challenged the award of the PLA Puri. A few minutes back, your Lordship was raising the same contention.
I am not raising any contention. जो कैसे से कैसे भूल गई। मुझे I have a selective amnesia. हाँ बस।
Now to challenge the order dated 27/2/2023 of the PLA Puri, your Lordship. Wherein basic procedure has not been followed. What they have done? They have straight away invoked the section subsection 8 of 22.
So what happened first? Tell me.
Lordship, the OP number 2 has applied for the fresh connection or domestic connection of 2 kilovolts.
OP number 2 who?
Lordship,
You are the private party.
Private party. She's a
You are for?
We are for the TPCOD, Lordship. Executive.
You are TPCODL.
Lordship.
Tata Power.
My lord.
Okay. लोग तो लूटू चाव कौन हो?
Next 54,000 was due. We asked for the no due.
So existing connection was there, and you asked for the no due.
No due certificate. But straight away the OP number 2, your Lordship, she straight away approached the PLA and she filed a PLA petition there.
तो PLA वाला कौन कहला conciliation meeting ही दिला?
किछि हला
किछि है नहीं.
we filed the written statement, your Lordship. After that से संगे संग February मास रे award pass कर देले कि connection दिया.
देखो, the present petitioner challenging the arbitrary award by the PLA, arbitrary award dated 27/2/2023 by the PLA, wherein the opposite party number 1, without appreciating the facts of the case in proper perspective, pass an award directing the petitioner to provide a new electricity connection to the opposite party number 2 on deposit of the required amount of new connection. Though the the opposite party number 2 had a previous connection which was snapped.
Lordship, it was closed actually.
Which was closed with an outstanding amount of rupees.
2,54,500 rupees.
500 rupees. Without considering this aspect, the learned PLA passed an award. What is the award?
Annexure 6, your Lordship. Sorry, 7, your Lordship.
PLA passed award.
Page 32.
Directing the petitioner to provide new electricity connection, ignoring the earlier outstanding dues. Earlier also it was Tata Power or somebody else?
At that time, Seshu was there, Lordship, but Tata Power.
Seshu jaha liabilities सब अपने नहीं गले.
Yes, sir.
Liability assets सब नहीं गले. jaha Seshu जो टा पैसा दिए नहीं थे तो अपन collection के right है.
Again, Lordship, sure.
You got that? Generally, company, suppose one company is running, another company is taking over. So that is there will be agreement.
Yes, sir. But our it is
agreement रे आपनकर से तार जो pending तार
dues गुड़ा
पाइवर थी.
मतलब
आपनकर अच्छी की.
अच्छी है.
कोड है देखिए.
Lordship, say I'll produce that document.
That is very important. That is not थी वाला आपन कहीं से आपन को देंगे.
नहीं अच्छी. ये Lordship हम say liability सब हमारा अच्छी.
Suppose आपन labor suppose good for example. आपन previous company labor 10 टा थिले. तो एग्रीमेंट रे लिखा हितो जे नहीं ए लेबरर को भी मु नेबी किंबा लेबरर को मु एति पैसा देके ताको सेटल करबी ए सब थिबा थाए तो similarly if any outstanding dues of the previous company is with anybody in the state,
yes, sir.
the Tata Power will take over.
Is
there any agreement like this?
I'll produce that on the
petitioner to serve the document. At this stage, petitioner wants to show the agreement which reflects that the outstanding dues Pending with different consumers. According to the previous operator.
Consumer. Previous consumer.
Consumer can
Operator.
Operator should be collected by him. List the matter on 3rd October.
I filed an IA for the stay of the.
आगे फाइल करो नी हम कन्विंस न लेकिन स्टे करो यदि से थिबो न थिबो किछि देन
नहीं well I'll produce that.
এটা मेन डॉक्यूमेंट.
Item number 9.
9.
I have appeared for the LIC.
Which for the
Yesterday, I've appeared for the
Bhujavala?
LIC
You are
yesterday.
for the Bhujavala?
My lord,
What is your case?
my lord, this is a petitioner is a 100% blind person, my lord.
100% blind person.
100% blind. Physical disability certificate is annexed.
What is the issue, sir?
An issue, my lord, for a release of the accidental death of the release of the death claim of a
The petitioner his father died and you are claiming that to ଆପଣଙ୍କର disability ହେଲା ନ ହେଲା ହେଲେ କଣ ମିଳିବ ମାନେ sympathy case ଟା କହିବେ ନା sympathy ଆଗ draw କରିବା ଚେଷ୍ଟା କରିବେ. Sympathy is not going to help you. Case ର principle help କରିବ ଆପଣଙ୍କୁ. Yes, petitioner father died, then what happened?
The death claim of LIC policy has not been released, my lord. Therefore, my lord, last of it.
So yes,
I appeared yesterday. It was supposed to be listed yesterday, could not be listed. And the policy was taken in commencing from 2007. He died in 2008, before 1 year. And he has lost the claim. He has not lost the claim. The
can you repeat? Policy was taken in 2007.
He died 10 months after in 2008 of an accident, road accident. Perhaps that is not permissible to be paid. So I will take instruction. I will take
LIC policy
and he represents
କୋଉଠି ଆପଣଙ୍କର କୋଉ ପଲିସି ଲେଖା ହେଇଛି ସେମିତି
ଅଛି କେତେଟା ଅଛି accident
ମୁଁ ଜାଣିନି ମୁଁ ଆପଣ ଦେଖିବି ମତେ
ହଁ ମୁଁ ସେ ପଲିସି କଭର ଦେଇ
ଜଣ ଲୋକ ତାହେଲେ ନେଲା ମାନେ ସେଇ ବର୍ଷରେ ତାର ଭାଇ
କାଉଣ୍ଟର ଦେବି ମୁଁ ଡିଟେଲ କାଉଣ୍ଟର ଦେବି ସେ 21 ରେ ରିପ୍ରେଜେଣ୍ଟ କରେ
ତା ଅର୍ଥ ହେଲା ଯୋଉ ଲୋକ ନେବ ମୁଁ ସପୋଜ କାଲି ନେଲି ପଲିସି ପରଦିନ ମରିଗଲି ତା ଅର୍ଥ ମୁଁ କିଛି ପାଇବିନି
नहीं ସେଇଟା ନୁହଁ ଗୋଟେ କମିଶନ
ମାନେ
ମାନେ ପାଇବ नो डाउट ପାଇବ କୋଉଥିରେ ପରମିସିବଲ କୋଉଥିରେ ନଟ୍ ପରମିସିବଲ ଅଣ୍ଡର ଦି କଣ୍ଡିସନ
କୋଉଠି ପରମିସିବଲ ନୁହେଁ ମତେ କହନ୍ତୁ
ମୁଁ ସାର୍ ଟିକେ ଦେଖିବି ସେ ପଲିସିଟା ମଗେଇ ଯାହା ଜିନିଷ ମଗେଇ
ଏଟା ଆପଣ ଆଗରୁ ବି 2 3 ଥର କହିଲେଣି କିନ୍ତୁ ପଲିସି କେବେ ଦେଖୁନାହାନ୍ତି
नहीं ମୁଁ
ଆଗରୁ ବି କେସ
ଏଇ ଦେଖ ଇଟ ଇଜ କଣ୍ଟ୍ରାକ୍ଟ गिवर ବା फाइट द्वितीय कथा at the cost of a lot of genuine policy like lordships me these fake claims cannot be
सर से फेक बोले आपण केंदी प्रूव कले
ମୁଁ କହୁନି
फेक बोले केंदी कहले आपण से तो फेक करिनी
नहीं काउंटर देखिए कौन करता
जबरदस्ती आपण फेक बोले कह देले केंदी
नहीं ମୁଁ କହୁନି he might get
then how do you know beforehand you can fake बोले केंदी कह दे
पाइन ये केस विषय
because before I mean certifying I mean his fakeness is certified by anybody you can't say fake
नहीं ମୁଁ सर in generality मैं कहूँ कोई को काउंटर देले अपन लिखिए एक केस से कौन फैक्ट है
फाइल काउंटर दिस द मैटर ऑन 27 रस
ताकि मुटे रहूनी से वेट
थर्ड रस
हां सर he counter
I have some mercy on poor
yes,
blind person he can't
on the other day I considered the case because 4 lakhs were due to he withdraw you should pass out you are not pressed from
जोड़ा देखो जोड़ा genuine लागे जोड़ा ठीक लागे मु ये कर जोड़ा ठीक न ना I already I reject पर जोड़ा genuine लागो तो सही जगह
I have great faith in your lordship's judicial acumen I have great faith
but the only thing आपण कहंतु जे 10 months जो केते दिन भीतर एक्सीडेंट हला कि कोन डेथ हेगला से पाइबो आपण पॉलिसी को पॉलिसी सेटा अछि मन देखा
हां देखिए तापर आउट दा सेटा क्लेम का भी लॉस करनी लॉस
करले पछे देखिए सर he is a blind man try to understand his position also yes have some mercy on the people who are
blind disabled we will take
ମୁଁ ସେଇ ग्राउंड रे ताको देबी
हां
आपण आगो मते देखांदो हमर पॉलिसी थिले भी देखि देबी आपण policy भी कहूतो देई पारिबने फिर भी देई अगर कोई दूसरा आपण कोई
We have a lot of sympathy for a blind person.
sympathy ये देखले तो problem. Yes, fine. ये तो मेंशन करने में माहिर है लेकिन कोई शेयर लेती So how much time is it?
हमें complete ही गलानी
And consider the petition state submits that the investigation has already been completed, hence no cause of action survives in the present CM. According to this, to stop. Next.
Item 13.
May I please, my lord? My lord, this is the case of the.
Yes.
May I please? My lord, this is the case of Sikha Sahayaks. On last occasion, I was on VC. Your lordship said that come to the court and we'll discuss.
Yes.
My lord, there are only two issues your lordship was interested in knowing. That the opposite party is saying that they do not have records. And your lordship also asked me the question that why this 2003 matter is being taken up in the year 2020. I seek 2 minutes time to completely place the case. My lord, first, why my opposite party friends are saying that there is no record available? Because your lordship, while appreciating the case, clearly identified that there has been a mistake in calculating the ORV reservation. So on 2 occasions, your lordship sharply asked them that why they have committed the mistake. So just to escape your lordship's anger, they have taken this plea that the records are not available. Whereas the fact is, they have used all the records in filing the counter to this particular case. So all the facts, relevant facts that are needed, all the facts are with them. Now coming to the question that why this 2003 matter has been taken up in the year 2020, your lordship. Your lordship, the petitioners were appointed in the year 2003.
They have been selected.
My lord. Selected and continued. Yes, my lord. Appointed.
2003.
My lord. Selected, appointed.
Then what? Appointed.
Appointed.
Isn't that Rishikesh Bindani?
No, not. That's what I'm saying. In 2 minutes time, I'll finish. My lord, we are appointed.
So you are selected and got appointed.
Then in 2006, they issued a disengagement order, and that was, my lord.
Citing what reason?
No, citing that Rishikesh Bindani. There was a case where the subsequent appointments post 26/9/2003 were challenged. So on that ground, they issued a disengagement order. That was stayed by this court and ultimately set aside in the year 2015. Now, in the year 2015, while this honorable court set aside that disengagement order, directed the opposite parties to take a fresh decision, giving an opportunity of hearing to the petitioners. And the department.
Now, what is your position? Are you working there?
Yes.
You are working.
We are working. That is what we need to be regularized. Our regularization is not being done because they have said that we have completed the process of.
You are working now, not regularized.
No, that is the point. And that not regularizing because they have made a miscalculation of the ORV Act. That is why they are not. I apprised your lordship that 40 posts are lying vacant. And because of their miscalculation. See, that is the point. Because
his entire contention is based upon a letter from the collector in 2004, saying that so many seats have been reserved for SCBC, so many seats have been reserved for general so and so.
You are SCBC.
SC. ତାଙ୍କର allegation ହଉଛି ଯେ SC ପାଇଁ ଯେତିକି reservation ହବା କଥା ସେତିକି ନ ହେଇକି SCBC ପାଇଁ ଅଧିକା ହେଇଯାଇଛି and therefore
ଆପଣ କରୁଥିଲେ ତ ସେତେବେଳେ
and those seats have been left vacant.
54% ସୁପ୍ରିମ କୋର୍ଟ ଦୁଇଟା କେସ୍ ଏବେ ପେଣ୍ଡିଂ ଅଛି
54%.
54% total ଆପଣ ଦଉଥିଲେ 50 64 sorry 60
SCBC have been laid vacant. They have allocated it, but they have appointed exactly the number of seats that is legally allocated.
One thing, consider this case. The state is directed to.
My lord, 20 years have passed. Kindly, they should ask because.
What is the age?
Is my lord, 20 years. Your lordship can calculate at least 20 years, 40 plus.
Now, what is your age?
37. 37, 40. There are 7 petitions.
Government ତ ସେମିତି ଏବେ କଣ 35, 37 ତ ଚାକିରି ଦଉଛି ଲୋକ ବି ଆହୁରି ଡିମାଣ୍ଡ କରୁଛନ୍ତି 42 45
their posts are vacant.
You want regularization.
My lord.
Then consider the petitioner submits that. You have gotten a rehabilitation at assistant?
No, no, no. It's a regular appointment,
Oh,
contractual.
after deducting from the, okay, sorry.
My- All their peers have been regularized. Because of this miscalculation, these 7 petitioners have been left out.
Land Conservation Commissioner states, submit that because of the miscalculation of the state government, the petitioner being a SC candidate would not be observed as a regular employee. Hence, the petitioner is, though she has worked for how many years?
20 years now.
Though she has worked for 20 years, her post has not, his,
7, there are 7.
their
There.
posts are not regularized. Who is the authority?
The authority is OP2 can do it, but it is done by the collector actually.
Collector.
No.
In view of the such
Fine.
the facts and circumstances of the case, the collector, who is court distributor?
Gajapati district.
Collector Gajapati is directed to consider the
Well,
case of the present petition. Rohantu, I am putting in my way on you. Don't disturb me. Consider the petitioner's case for regulation. It is stated that petitioner stated that though there are 40 posts,
40 posts.
there are 40 posts for SC.
No, 40 posts wrongly allocated to SCBC, but those 40 posts are kept vacant. They have filled only the legally entitled.
So there are 40 posts allocated for SCBC which are lying vacant and no person has been regularized.
40% wrongly.
And if law permits the OP number 1.
Fine.
Sorry, OP number 1.
Secretary School and Mass
OP number 2. OP number 2 shall put forth the proposal before the OP number 1.
My lord, the collector would be doing it. OP number 5.
It doesn't have to take permission of the
Yes. So,
secretary.
yes, that has to, yes. That has to be from OP number 1.
He has to take.
My-
3 and 5. 3 is USEPA and 5 is collector.
Oh, so in coordination with the concerned authorities, concerned authorities, that is OP number 1 and
3 and 5.
1, 3 and 5. And try to find out a solution to the problem faced by the present petitioners. The petitioners being experienced for the last experience and have served experience, and they have served for about 20 years in this same job. They deserve to be regularized. I can't say this, you regularize them. They deserve to be regularized. They consider what is the situation. I don't know. ଆପଣ କହୁଛନ୍ତି ଆପଣ କଥାରେ ମୁଁ ଲେଖିଲି ବାକି ସେମାନେ ଦେଖିବେ ନହେଲେ ଦେଖିବେ
ଗୋଟେ minute, my lord.
ଆମ representation
No,
distribute
representation not.
ଏଟା ମୁଁ ହେଟେ
Counter and everything I have also given it.
ଏଟା ଗୋଟେ positive order ଭଳିଆ ଲାଗିବ କିନ୍ତୁ ମୁଁ ଏଟା ବି ହେବନି କି I have passed an order to do this,
my
do
lord,
that.
my lord, ଗୋଟେ minute ଯଦି my lord ହେଇଛି କଣ ତାଙ୍କର appointment ଟା ସେମାନେ
Sir, I know that, let them consider ନହେଲେ ଦେଖିବେ
ଜିନିଷଟା ହଉଛି ସେମାନେ
ଲେଖ ଲେଖ
irregularly 40 post ଦେଇଦେଲେ SCBC କୁ।
ରୁହନ୍ତୁ dispose କରିଦେବେ ବାସ୍ ଆଉ ନେକ୍ସଟ ଦେଖିବା ନହେଲେ ଦେଖିବା ଆଉ ଥରେ ଆସିବା ଆଉ କଣ କରୁଛନ୍ତି ଦେଖନ୍ତୁ
ଗୋଟେ ଟାଇମ
I hopefully ହେଇଯିବ
ମାନେ ଗୋଟେ ଟାଇମ ଷ୍ଟିପୁଲେସନ ଯଦି କରିଦେଇଥାନ୍ତେ
ଟାଇମ ଷ୍ଟିପୁଲେସନ ଦେଲା ବେଳେ ଲାଗିବ କି କୋର୍ଟ ଅର୍ଡର ଦଉଛି ରେଗୁଲାରାଇଜ କର
ନହେଲେ ଦେନ୍ ତାପରେ କିଛି ବି ହେଇପାରିବନି କେତେବେଳେ
ଷ୍ଟେଟ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ପଳେଇବ
ସେଇ ତ କଥା ଗୋଟେ ଟାଇମ
ରେଗୁଲାରାଇଜ କର ବୋଲି କହୁଛି ଏତିକି ଆପଣ ଯାଆନ୍ତୁ ଦେଖନ୍ତୁ ନେକ୍ସଟ
Item 14.
14.
I'm for the petition. And I prefer short adjournment to file my rejoinder.
Last occasion.
କଣ କେସ୍ ଟା କଣ ରିଜେଣ୍ଡର କଣ ଜରୁରୀ कौन case टा?
Is it, I have availed a loan of rupees 65 lakhs.
65 lakh. For
My
what?
lord, for a manufacturing unit, for built
What?
manufacturing unit.
Brick. कौन manufacturing? कौन manufacturing?
Chakki atta besan manufacturing.
Chakki atta besan, okay. तापरे?
After that, they have sanctioned 20 lakhs rupees and disbursed this amount. Thereafter, they recall the loan.
Why?
Reason that during the application, I have not disclosed some facts.
Naturally, they have the right to do that. They are the banker, right? They are banker. You are the borrower. They are the lender. They can do that. But what are the disclose? What are the things you have not disclosed?
That I have another account in UCO Bank.
Account NPA.
And
Guarantor account is NPA. 95 lakhs.
Borrower हिसाब रे वेना account हिसाब रे थोड़ी है borrower हिसाब रे
But they have sanctioned sanctioned amount.
ती पाइगले खुशी हुआ तू.
ये बर्तन account NPA चलानी. 13 करिपनु stay order अछि बोल 13 भी करिए. Stay order अछि एटा केस रे.
किए दी stay order?
ना 22/9/2022 रे stay अछि.
Stay order तो मंथ केस.
ना अपन
Stay order केबे अछि?
22/9/2022.
Stay order stay order ना असुना ना बैंक किछि करि परिबे
ना 13 करिउनी सरफेस एक्शन नेउनी account NPA चलानी.
With the order, stay order,
22/9/2022. Number 2.
As interim plan, no coercive action shall be taken against the till next date. Next date, okay, Ashilani, nahi? Okay, let us stay order vacated.
Not sought adjournment.
No.
It will be come 18th.
No, sir. Bank cannot be left high and dry like this. Because public money, they are dealing with public money. ଆପଣ bank ଭାବୁଛନ୍ତି କଣ ଆପଣ କାହା ପଇସା ଆପଣ ମୋର ପଇସା
They had sanctioned the amount,
Sir,
and that
sanctioned
is why I have invested my 21 lakhs.
some facts we have suppressed.
Surface the fact man annexure page number 11. Page number 10.
Time
Not a short excerpt.
short for nine. The petitioner challenges the letter dated 29/6/2022 issued by the opposite party. Opposite party number कितने? Okay, लगा. The fact of the case is that the petitioner had availed a loan in order to set up a manufacturing unit of chakki atta, besan, etc., which was estimated to be costing of rupees 86,85,000. Out of that, 33,35,000 was sanctioned by the bank towards machinery, furniture, and fixture, conveyance, water resource, electrification, etc., etc. Rest 53,50,000 was allocated towards the working capital requirement. In order to meet the financial requirement, the petitioner approached the opposite party for extension of necessary credit facility to meet the financial need in setting up the unit. Hence, the opposite party bank, satisfied with the financial credential of the present petitioner and decided to sanction 25 lakh and cash credit limit of 40 lakh. Hence, the bank decided to sanction 65 lakh in aggregate for the project, wherein the project cost was 86 lakh 85,000, requiring the petitioner to arrange and invest a sum of rupees 21 lakh 85,000. However, the opposite party bank has disbursed 20 lakh as term loan, and the petitioner investing in his own fund towards the balance cost of the project. Full stop. So total amount कितना पहले 20 lakh.
20 lakh.
20 lakh. Okay. The petitioner is constrained to approach this court for getting the rest of the loan amount. Full stop. And concern of the bank submits that. However, the bank has withdrew the the,
Recall the loan.
what did you say?
Recall the loan.
Recall kate.
That 20 lakh.
Entire amount recall.
The bank, however, the bank, on which date? However, later.
29/6/22.
29/6, on 29/6/22, 9/6, na? 9/6. 9/6/22, the bank has recalled the whole amount, citing that the petitioner had not disclosed that he had another NPA account.
Guarantor. Petitioner wife hochi guarantor. PA belt kochi Eco Bank.
Oh, petitioner was the guarantor in another NPA account.
Eco Bank.
Before, with the Eco Bank. So, in such view of the matter, the impugn order issued by the bank doesn't suffer from any infirmity. Sir, accordingly, the writ petition is dismissed. And any interim order was by this court.
Item 15.
Item 15, my lord. On Monday, we received the rejoinder, my lord. We filed short reply.
Instruction. Sir rejoinder, sir, kete sir kari. Gote to rejoinder la. Tabara sir rejoinder hava. Tabara fir sir.
There is a noting that rejoinder has not been issued, but I have filed it since 8th.
Amar anyway, they should find out the rejoinder. You want to file anything. There is not rejoinder, sir. That is additional affidavit.
Additional.
Don't change nomenclature wrongly.
The MSME award, my lord. Your lordship has passed a recent judgment that is covered by this MSME award against.
Oh, MSME.
Again. Pura clearly what are the ingredients, and the award does not meet any of the ingredients.
Let's see. You want some time? Here for sir.
Initially, I already for your lordship again the award of the in the first case, there is a confusion.
Yeah, for.
I am just clarifying. In the first case, there is some.
Oh, yeah, in the second case.
Yes.
Oh.
He is in the second case for the same appellant, because out of one award, there are 2 appeals now.
Okay. So finally, 25th. Let's finish it. Similar the order also.
26th or 27th.
26th. Okay.
26 तारीख.
Oh, next.
3 tags.
Next, South Co.
3 tags. All 3.
Slowly,
Sub 3 tags. He is appealing.
All let's here together. List the matter on 26. All. Then.
Item 18.
18.
Your lordship, I am appearing for respondent in the present matter from Mumbai online.
But lordship, this is a case. Lordship, this is a case where lordship we have been pleased to issue the notice to the opposite party, Mr. Sherkhan lordship, and the opposite party is to file the counter lordship. That is the why the case has been posted to the lordship.
Your lordship, I think. Yes, sir.
Mr. Tiwari, you file a reply.
Sir, we are filing our preliminary objection today itself, along with the Wakalatnama. And
why don't you file a objection by reply?
So, this is a preliminary objection in context to maintainability and admissibility, because we are at the stage of admission. Because if you look at the Roznama, it is showing online as admission. So, as far as admission is concerned, we are objecting that admission by way of our preliminary objection application on 4 major grounds. One is the limitation, second being the jurisdiction.
Lordship, let him serve that copy.
Allow me to speak. Allow me to speak.
Just a minute, sir. Let him. He's saying something. Just wait for that. You wait for your turn. Both are in the VC. Have some discipline in VC. Okay. You just keep quiet till he completes. I'll allow you to argue. Then you argue. Yes. Please.
Third is in compliance to subsection 5 of 34, which is a prerequisite condition that a notice needs to be served, which has not been done by him. and 4, the matter being res sub judice. These are 4 major grounds which we are raising before this honorable court in our preliminary objection. As your lordship may be aware that on pure question of law, that question can be raised before any forum at any given point of time. And your lordship may just look at, I'll just like to draw your attention, if you give me just 5 minutes. If you look at the page number 1 of the petition, he has filed this petition under section 34 very clearly. That means setting aside of order. Your lordship may look at the petition page, running page number 1. The first line itself.
Yes.
An application under section 34 of Arbitration and Conciliation Act. This means he is filing this petition for setting aside of an award. Now look at what award is he challenging. If you look at the award, your lordship, it's on the second page, running page number 2. He is challenging, by way of this proceeding, is challenging award 23 Jan 2018. And look at the date of his filing. His filing is application.
Mr. Tiwari.
Yeah, yes.
Let me fix for final hearing. Even your preliminary objection, everything will be culminated into that argument. So let's fix for 22nd at 2 p.m. I'll finish it within 10-15 minutes. Okay.
Grateful, your
That will
lordship.
be better because in the meantime, you just copy. You have got the copy, Mr.
No, lordship, I have not received the copy. The preliminary objection copy I have not
Meantime, let him go through the copy also.
Your lordship, one request can I make? In spite of 22nd, can it be 21?
21, no. Okay, 21.
Lordship, I am sorry. In 21, I am little bit busy. Lordship, your lordship may call this matter last week of September, 27, 28, lordship.
26.
Lordship.
Okay, 26.
Grateful, your lordship.
Lordship, in the meantime, my friend may serve the preliminary objection copy to me.
See, my
this copy, give you a copy to this.
I serve the copy. Yes, ma'am.
Lordship,
the local council will give a copy to you.
Lordship, may I know the name of the local council who is appearing at Cuttack, Lordship?
Abhishek Agarwal.
Abhishek Agarwal.
Lordship, all right, I am asking my associate, he will collect the copy from Mr. Abhishek Agarwal.
Yeah. You do one thing. He'll leave a copy here, he will collect from you. Otherwise, you will never meet each other. Okay? ଆପଣ ସେ ଖୋଜିଥିବ ସେ ଆପଣଙ୍କୁ କହୁଥିବେ ଏଠି ଯୋଉଠି କପି ଛାଡ଼ିଦେବେ ସେ ନେଇ Do one thing, Mr. Vishwal.
Lordship.
Tell your associate to collect a copy from our court master. So he is leaving a copy here with the court master.
Lordship, I am asking me.
So you tell your associate to collect from there, and otherwise you may not be able to meet him, and I don't know what to do. So again we'll ask for time.
May I suggest, my lord?
Yes.
Yesterday there was an office order by the registrar that without serving the copy they cannot file it. So if it would not be solved, then my lord and friend
You have
cannot
not
file.
filed yet.
No,
You have not filed.
No.
Then you have to do one thing tomorrow. Today get it collected today, sir. Mr. Vishwa. Today you get it collected.
Lordship, I will collect right now within 5-10 minutes. I am asking my associate, he will collect.
Because without showing that you have given to him, that matter will not be listed on that day.
Lordship, I am receiving.
New rule has come.
Lordship, I am receiving the
copy. File before 3 days of listing of the matter. First, second, you have to show in the registry that you have served to the other opposite party. You have to show the signature. Then only, no forgery. Okay. Next step.
Item 19.
Please, Lordship. On behalf of Mr. K. Madam, my senior is bedridden. She met with an accident.
Yes, you can say, simply say, my senior is, he is unwell. Please simple. Bedridden.
He met with an accident.
What is a co-part? Simply say unwell. I don't ask. I don't inquire.
My lord, once on the commission, I cannot stand on the way, but the matter can be disposed of. It is a transfer matter of the GRS. In the meantime, your lordship knows there is a notification has come.
Just a minute.
1 week's time.
Now what?
It was for filing reason.
Transfer of GRS, my lord.
So he has been transferred.
The transfer has been stayed by your lordship.
Okay.
In the meantime, the notification has been come as per your lordship's observation.
Okay.
They cannot go beyond the block. let them file an appeal before the appellate authority, and the appellate authority will consider this one as per this.
Let it come. Well, since there is an order of stay, if a lordship may kindly adjourn it to any day next week on day of meeting.
You come prepared. If your senior is not ready, you come prepared and argue. Okay? Further, no time shall be given to you. Your senior may not be well, but you are well. You can argue. Come prepared.
What's the day? Fix a date.
Let's say matter on 29th. Next.
Item 20.
20. Where is the other party?
You can raise this matter, fix up 2 PM on the 27th. Finish up. 10 minutes.
What is the matter now? Why is so much time?
Doesn't matter.
You go to the, I am sending it to
Yes,
the
that
appropriate authority.
खाली गोटिए point अछि legal point that my lord will interfere.
Out to the
काहे कि सेटा election tribunal अछि तो tribunal टा 15 दिन भितर करिया कथा election न ये गोटे defeat मोटे कोन इटा defeated candidate नु गोटे legal point देखि जदि सेटा न होला then I will go to
Here,
not
defeated candidate की ये
defeat जमा हेई नाथि याकू पूरा प्रथमरु ताकू contest करे constitutional right to देलेनी bar council तो देखिला
but that can also agitate
नहीं मु खाली गोटे पॉइंट कर जेतल बार काउंसिल जानि कि इलेक्शन प्रोसेस जदी स्टार्ट हेइ छै माय लॉर्ड व्यू जदी एटा रहला बार काउंसिल गोटे डायरेक्टिव एडमिनिस्ट्रेटिव इशू ऑर्डर करथिला काहू इलेक्शन अफसर एटा आसु मु
आसु नहीं हेरे रखबे किछि नाही मैटर काहे
से ट्रिब्यूनल को लेंगे जस्टिस सॉरी
से सेक्शन टा केते कहले
अरे ये दिस इज द रूल योर लॉर्डशिप में काइंडली सी द रूल
नहीं नहीं सो रूल टा अछि डिफीटेड कैंडिडेट मु से गोटे पॉइंट खाली हजू माय लॉर्ड कहिबी जदी से दैट पार्टी एटा दिया
रूल
Rule 5.3, your lordship that are flag marked for.
Okay. You are for the.
I'm for my lord. Opposite party number 3. And opposite party number 2, my brother
three submits that since there is a the provision of election tribunal.
55 पे टिके मैं
for the
55 पे
Orissa State Bar Council Association Rules 2021.
55 पे टिके खाली बोलो 1 point. Here it is reflects because already election process was started. But the bar council has exercised administrative power. When bar council is the apex body of the all the, they have directed Annex 7 mirror kindly see. ताकू कहले election officer से जो लोकटा देइची proposal ता नाटा या करी तमे ताकू रेगुलराइज करो से इलेक्शन ऑफिसर तक कोड करना गया ऑन को
से इशू भी तो ट्राइब्यूनल सामने रेज करी है ना
ठीक है खाली 55 पे खाली देखो
देखिए नहीं ट्राइब्यूनल सामने अपन जा इशू पेंडिंग इशू रेज करिए हला
अच्छा तले बलड आई बाउड ऑन लॉर्डशिप्स व्यू लेट
इलेक्शन ट्राइब्यूनल consisting of 3 as per election the said tribunal the issue raised in the present writ petition can be agitated before the tribunal and the tribunal shall pass order at the earliest possible, preferably within 3 months.
And one aspect, Millard, it was 15 days delay may be condoned that direction.
If there is any delay in filing the petition before the tribunal shall liberally condone the delay.
My lord, 14 and 5 is there. But condonation delay, section 5 and 14 is there. The lordship knows that.
If we tribunal nahi, my lord direction de dele se nahi. Say direction टा हो say direction is bar council to take endeavor all to constitute
tribunal में पढ़े दिले से करिया कथा तो करिए मु कोन
आगे
the tribunal that had
खाली bar council be directed to expedite that
my lord our appearance may be record opposite party number 2 I am appearance
कागज दे दूं आपण
my lord can I take back the copy and give a photostat copy of the bill
नहीं take
ना मु दे दूची अछि मो पाखरे
सेक्शन लिख देबो ना सेक्शन लगा जाओ कोन दरकार
Tell the bar council to expedite the constitutional tribunal.
And if the tribunal has not constituted yet, the bar council of India,
Odisha,
no,
state bar council,
state bar council is directed
to take immediate effective step for
tribunal at the earliest, preferably within 15 days from today, and start hearing the matter.
And tribunal also has the timeline. They have to finish up because election is tribunal public. ना 3 मास तो तको रहिची
3 मास मैक्सिमम तो आगर मास एग्री कर परंतु समय 5 दिन
and in fact tribunal
upper limit 3 months
tribunal has already been formed because once the
if not
yes But one Annexure 7, State Bar Council directed the election officer that.
How do you raise there, sir? Next.
Item 21.
21. 21.
Negotiation is going on for settlement of the loan account. I will let it
With
come
whom? Negotiation with whom?
the opposite party to bank.
Bank.
I have already
Ramya
served.
Bank.
I have already served the copy.
Who is the council?
Mr. Aravinda Mohanty was received the copy.
Something nine.
Is not available. His name is not appearing. That's why he's perhaps is missing. Any day, 15 days.
15 days time. And time. Just a matter on 5th.
Much
October. Next.
Item 22.
I am on MR.
22.
My love, item 22, your lordship has fixed the similar matter yesterday, that vigilance case matter, my lord. Lokayukt versus vigilance. On 25/9, this is also.
Since the similar matter in section 25/9. Matter number.
No matter. Nice, immediately.
Next.
Item 20.
Short date, 29th.
25.
25.
Item 20. 23 urgent.
24.
Item 24.
24.
May I present? In this case, matters counter not filed matters. The matter related selection of asset matters.
I'll file the counter.
Now can we state 2 weeks time to file the counter? This is the matter on 6th October. Next.
Item 25.
25.
25, my lord. Last occasion notice has been issued, my lord.
State Bank of India.
My lord.
Yeah, State Bank of India.
My lord.
State Bank of India, Mr. Kora is also there.
I have taken instruction that, my lord, the petitioner has not submitted the complete documents, my lord. On 11th, he has submitted the complete documents and the bank has uploaded the same for instance.
So what do you want now?
Time like this,
2 weeks after us,
time like this.
Petitioners 2 weeks time. This is the matter on 18th October. Next.
Item 26.
Item 26. My the pension account of the exertion was freeze pursuant to instruction by the police. Plus, you have last option directed to take instruction to my understand.
So you have got that? I have not received
My
a copy.
I have taken instruction that the police has given a letter to freeze the account, my lord.
That's fine.
That is the state government's.
What is the?
I have sought for the instruction has not come yet.
I want the state.
I am the opposite, but no 2 million Punjab National Bank. What my
This is the matter on 26th.
My name may be M.K. Mahapatra for bank.
opposite, but number 2, my name is Manoj Kumar Mishra.
State Bank M.K. Mahapatra.
My name may be deleted. My name. Okay. Good luck. Last. Next. 27.
27
Yeah.
Item 28.
28, the 2014 matter, I have PWC, but the records are not there. So I have called for the records. 2 weeks, I'll file the count.
First time. I'm on state 6. 12 October.
Right.
29.
29 urgent. Urgent.
30.
30.
30. Non appears. List the matter on. October.
31.
31. Ready?
Matter relating to selection of Hon'Ble worker.
Just asking. Take out here.
My lord, 30, my lord.
Yes. What is the matter?
Well, the loan council for the state has been directed to file the counter.
You can come, madam, 2 weeks.
Last chance maybe. My lord, बहुत थोड़ा नीले टाइम है और last chance.
Last chance. Next.
31.
31.
Selection of Anganwadi worker, my lord. In the year 2006, notification was issued for Anganwadi
2006,
my lord.
6.
For engagement of Anganwadi worker in respect of Korkora Anganwadi Center, my lord. Petitioner and other candidates applied for the said post, and one Lakshmi Priya Nayak Barik has been selected. Petitioner filed her objection as she has submitted a false document for certificate under RTA Act.
RTA Act for jana padi.
No, she's right, because now she has been disengaged. That post is vacant. So there was an advertisement for new post. New selection. That's your challenge.
I am the eligible candidate.
Sir, madam, apply karantu.
No, my lord. At that point of time, I have filed objection.
She was never selected.
I was not selected because of Lakshmi Priya Barik.
Lakshmi Priya Barik ho
never eligible.
I am the eligible candidate, my lord.
Eligible hai gala selection hai gala ki na.
My lord.
Eligible 10 ta log hai.
No, my lord. I am the petitioner has secured more mark and she is the eligible.
Apply there. Now they have since
new advertisement is there.
Cancelled.
No, cannot cancel on my. May I submit my
petitioner is directed to approach.
May I submit my
apply for the.
May I submit?
ये 2006 का revive करी परिविन. I don't have. I can't do that.
May I submit? Kindly hear me for a moment.
I am here.
On my application, her candidature has been rejected, my lord. Inquiry is conducted.
What are you saying? Yes. Bolo.
On my objection, her candidature was rejected, my lord.
So
I am the eligible candidate.
So what are the objection?
As she has submitted a false document and petitioner filed a number of petition before this honorable court, and this honorable court has directed to cause an inquiry.
The best option would be
move to next
they have
eligible.
cancelled, you go and apply. You were eligible, you will get it. What's the problem?
I'm waiting since 2006.
Why? Who told you to wait, madam?
As she has submitted. More eligible at that point of time.
Eligible doesn't entitle you to get some job. Eligibility, mere eligibility doesn't entitle you. The petitioner's mere eligibility doesn't entitle her to get the job of Anganwadi worker. Hence, it will apply. That's best. So, in the land council of the state has submitted that in the meantime, the advertisement has been cancelled.
Advertisement was
election was cancelled.
No, advertisement.
The
advertisement fresh
cancelled and a fresh advertisement has been made on coded.
Hey, you also kindly say page 52. Hey, my no, hey, my instructions is by hey.
Apna instruction na na sarkar.
More page 52 ro ache. More reject करके करी ना हंती.
क्या देवे पड़ा?
करी ना हंती.
ना hey, is right. Hey.
I
am भावितली ही चीज़ ही. No, no, PWC टा थिला था. I had not filed a counter. Eligibility was not there. So they have cancelled.
On your, I have faith on your.
No, my lord, as this first time, it will never happen again. My mistake. Admit it. No, admitted is my mistake.
So now, is cancelled.
It is cancelled. The post is.
Because
he was never eligible. Same record
page 52. My rejection.
She is never eligible on what ground?
She was never qualified.
Not qualified. There is no provision for qualification. As per guideline.
I have everything. I'll file.
It's a matter on 3rd October. Next.
32.
Matter counter time waste.
Written text is my lord.
Nobody, sir.
Is not eligible. Tell me.
Let me call for the record.
नहीं आपण आवे
ए, ମୋ ପାଖରେ PWC ଅଛି।
nothing ଏବେ କହିବେ ମତେ ନହେଲେ ମୁଁ
ନାହିଁ ମୋ
order pass
ପାଖରେ, I
କରିବି।
have that.
ନହେଲେ I'll make her eligible।
ମୁଁ ସେଇ list ଟା ମୋ ପାଖରେ ଦି ଜଣଙ୍କର ନାଁ
ନାଇଁ,
ଅଛି।
କଣ ପାଇଁ eligible କହିବେ ନାଇଁ?
Which is why, my lord, I need to file a counter, which is I'll say. Will that will let the controversy.
ଆପଣ eligible କହୁଥିଲେ ଆପଣ eligible ନାହିଁ ବୋଲି କହୁଥିଲେ।
List ରେ ଦି
ମୁଁ ତ
ଜଣଙ୍କର ନାଁ
କହୁଛି
ଅଛି।
ମୁଁ eligible ସେମାନେ କରୁଛନ୍ତି
ଏଇଟା କଣ ହବ? ଦେଖନ୍ତୁ ଖାଲି list ଅଛି, I have the list, which is why I call for them and file counter.
କେତେ ଜଣ total apply କରିଛନ୍ତି?
ଦି ଜଣ eligible ଅଛନ୍ତି।
ଦି ଜଣ apply କେତେ ଜଣ apply କରିଛନ୍ତି?
That I don't have that. And I'll call for it and file it.
MA pass, my God, MA pass ଟା কি এটা? হরিপ্রিয়া দাস।
That she withdrew. He withdrew from the
Basic education ହେଇଗଲା ତାର।
as a Lakshmi P. Bragg. The second one was there until 2022 when she was dismissed because of this forgery.
22 selection
That was
ହେଇଥିଲା।
22 ଯାଏଁ ଥିଲା. From 2006 to 22 she was working. Finally, when inquiry revealed that there was some problem with her certificate, she was dismissed. From then that seat is vacant. They were supposed to publish it. This is my instruction until now. She was never
ନା ହେଇଯିବ ଏତେ କଥା ପଢାଇଲେ apply କରନ୍ତୁ।
No, no, my lord, no. Count file କରନ୍ତୁ।
ନା ନାଇଁ ନାଇଁ ଆଉ କଣ କରିବି?
No, my lord, petitioner is eligible at that point of time.
Two names.
ହରପ୍ରିୟା ବା ସେ withdraw କରିଦେଇଛି।
Two names।
My lord, ହରପ୍ରିୟା withdraw her application।
ମୁଁ କହୁଛି ମନା କରୁନି। ମୁଁ ତ କହୁଛି number 1 is withdrawn. Number 2 was appointed.
ଏଠି କଣ ଦେଇଛି eligible କହିଲା। ଆପଣଙ୍କ କଣ ପାଇଁ eligible ସେମାନେ ଲେଖିଲେନି।
ମୁଁ ସେଇଟା that's what I will get and
You get the information.
ସେଇଥିପାଇଁ ହେଇନି
Allow the state to find out as to why the present petitioner was
declared ineligible.
Hello, let the matter be fixed for final hearing on 21st. Next.
32.
32.
Well, there are a lot of holidays.
କିଛି ମୁଁ ଶୁଣିବିନି। କଣ ଛୁଟିଆ ଇନଫର୍ମେସନ ଆଣିବି?
Because eligible କାହିଁ
Okay, 27 କରିଦେ। 27 next.
32.
32
I prefer short adjournment next week.
यार adjournment के सब लोग professional है।
My client has some difficulty. I want to talk with her.
Client कौन करिवो की? कौन केस टा कौन?
They have filed a counter.
कौन केस टा कौन?
I filed an appeal that was dismissed, my lord. This is
अंगनवाड़ी कौन है इधर? कौन तू? finalize. ଏବେ ନାହିଁ ଏବେ ଅଙ୍ଗନବାଡି ମାନେ ଆଉ କି time ମାଗିବେ?
Only next week କାରଣ
nothing doing.
some documents are required.
କଣ ହେଇଥିଲା କଣ?
Some documents are required.
କିଛି document.
Because the lady supervisor man he is not appearing. That's why notice was issued. Opposition file.
Release the matter on 15 November.
Yes.
15 November. Hello.
Item 34.
नहीं short
they were.
ଆପଣ ହିସାବରେ time ଦେବି ନା ମୋ ହିସାବରେ?
She is having health issue matter. Just sorted.
କଣ କରିବି? ୱିଡୋର ଆପଣ ୱିଡୋର କହିଦେଲେ କଣ ହେଇଯିବ କୋର୍ଟ ପାଇଁ ୱିଡୋ କୋର୍ଟ କିଛି।
Yes, sorted.
ସମସ୍ତେ ଗୋଟେ କ୍ୟାଣ୍ଡିଡେଟ୍ ବାସ୍।
Kindly man, sorted.
ଛୋଟ ଛୋଟ matter
Sorry, next day, sorry. Next day.
2012, 13, 14 matter ଗୁଡା time ଦଉଛନ୍ତି। You should feel bad about this. नहीं दे 16 17 अक्टूबर 16 की 17
Oblige.
Next.
Item 34.
34.
Your my lord, this is a case of a Anganwadi helper.
23 matters. Total 3523. I'll need to file it. 3523. I'll need to file a counter. 23.
You file counter.
16/8/23 notice is
25. 25 years. 25 चलेगा तो ना और इधर का।
I'll try for 25.
There is no interim order. Your lordship.
I'll try for 25.
25 कर दो। Next.
35.
35.
I may please your lordship.
I am for the notes opposite party insurance company. I am filing the counter affidavit notes.
You going to file or you
with
file?
counter affidavit notes.
सेट फाइल करो तो साइन करेंगे सेट देवे ना तो होनी। New system.
Yes.
Okay. The list matter कितने पे देवा?
Short date may be given.
Short date. आप rejoinder फाइल करेंगे?
My lord.
Rejoinder फाइल करेंगे? Will not file rejoinder?
I'll verify.
Okay, 29th.
All right.
29th
September.
It is required because I have disputed. It is own damage claim.
ठीक है.
Yes, sir.
Let him file the rejoinder.
Public.
2016 matter.
That is
29th है सब वाला.
All right.
That's all.